Hey, jerks, welcome. We are live and we have who you on here. Attorney Mark Bederow is in the green room. We were just chatting briefly. I know you all have been waiting patiently for a number of days. He's back on the show tonight. There's a lot to address, both in the motions, but also with some of the idiots online, some of the trolls. I have at least one or two cuts tonight I'm gonna play and some other things to talk about, but let's bring him up. Federal Law is on Twitter X if you want to follow him there. Everybody already knows. I feel like most people are following him. If you're not, you should be. He's one of the top criminal defense, a trial or a trial attorney. Let me say that right. A trial attorney, one of the top New York City trial attorneys, defense attorneys, criminal defense, murder trials. He's a top defense attorney in New York City. He's from Framingham, Massachusetts. He's been on the show like 60 plus times. Wicked happy every time he comes on our show and all the other shows he does. He was just on a bunch of other shows this week as well. Nurse Kim this week. You should check that episode. I'm pretty sure he was also on Melanie Little this week. Let's get him up on the show. It's always exciting and an honor to have Attorney Mark Bederow back on the show. Welcome, Attorney Bederow.
How are you? Has it really been 60? I need a better business model. I could be rich by now.
I know you've done well for us. You've done well for me. Yeah, because you know how I figured it out is we made a playlist and we started adding them all in, and it's over 60 episodes You've been on here. Right, okay. Just us. Never mind. I bet you've done another 60 on all the other shows too, especially like Melanie Little. You've done a lot of episodes with her as well.
Yeah, no, I definitely need a better business manager for sure.
You don't even ask. People have tried it. It's funny.
No,
you're not in it for that.
No.
It's funny because they came at you for that this week too. There was or a week ago, I saw one of them. I think it was Kate Peter. That's what it was about. That you weren't being paid. You weren't being paid for the YouTube or for the Karen Reed trial, and she was mad at you about that. Apparently, that was like a bad thing that you actually do things not for just money, right?
Sometimes there are things in life other than money. Of course, everybody needs some degree of money to live a certain lifestyle. But yeah, I'm not worried if people like her and some of her friends are so interested in my choices. As a lawyer, it's a privilege to be able to pick and choose what you want to do. And not everybody can do that. And so when you can be selective like that, that's a good thing. It lets you certainly, when you engage in any kind of pro bono work, pick and choose what it is. Most lawyers will tend to gravitate to interesting cases that they actually believe in when it comes to pro bono, as opposed to the other kinds of cases. If that triggers people who are obsessed with, online criticism of people, whatever, who cares?
Absolutely. And some people are noting Mazza tonight in the chat. He's not here. We would love to have him here. He's taking a break right now. I think the one message, we just want to send him love and honor his privacy right now. He's going through something. He's still 100% supports free Karen Reed. And in this show, he's probably watching tonight. We love Mazza. Just give Mazza love. Don't ask too many questions. Just let him be, please. Thank you for our moderator for posting that tonight. So there's been so many motions recently, and one of the wildest motions I heard you talking about this, discussing this on Nurse Kim the other night, was about this move by Brennan to put Karen Reed's attorneys on the stand. I've been saying this since they kicked you out, when they didn't allow you, all this stuff going on. It seems like Brennan does not want Karen Reed to have any type of defense, no experts, no attorneys. What do you think about that he's trying to put Karen Reed's attorneys on the stand? And is there any meat behind that? Is it a real thing here?
Well, I can't imagine why it would be a real thing, but if he's serious about it, in other words, if you played it out to its conclusion, he puts them on the witness list because he has the intent of calling them as witnesses, then he's not telling you the lead of the story, which is he doesn't want to try the case next week. He wants this case to be adjourned months and months because she's going to need new lawyers. You can't be a lawyer handling a matter in which you're a witness that you could be giving material information, which whatever that would be, would certainly violate what they call the witness advocate rule. This is the same issue, different factual circumstances, but the same issue that we raised in another case, which is still unresolved, 7 or 8 months later, involving Ken Mello and having him removed from that case. But, you'll note that was fashioned in the form of a motion to recuse before putting him on the witness list. Throwing her entire legal team on a witness list a week or two before trial without any notice or any motion like that appears like a stunt. It's a gimmick. It's newsworthy. And if there's a serious intent to call them as witnesses and he believes that's a real thing, then that would have to be addressed before the trial, because if he thinks he's calling them in the middle of trial, then you're in mistrial land. There's no question that this would throw the case into havoc. And if this is related to some of these TV interviews to, authenticate them, I don't know that that's really necessary. I don't think they're the right witnesses to have to do that. There are people from the production companies who would certainly be able to, testify if it came to that these are true and accurate recordings. This is what she really said. If it relates to some of the notes that they are seeking and they could do the same. You don't need her lawyers to do that. So it feels like a stunt. I mean, I think the only risk of any one of her lawyers possibly remotely even being a witness would be David on this other issue related to, this attempt to, access privileged communications between lawyer and client in the days that followed the arrest or the incident. Shouldn't even say the arrest.
Now, some saw on Twitter, some Twitter accounts after the Nurse Kim interview came out, they had posted this online and wanted you to take a look at it. It's basically something that was already submitted, from Elizabeth Little, and it's basically the privileged log. It's basically talking about only 2 text messages were sent between the client and another attorney, not Yannetti or anyone from the legal team, a guy named Jack Diamond, not Mr. Yannetti. If it turns out there's no text messages, does that blow up? Can that blow up in Brennan's face if there's not anything which he's been fishing for, which he thinks? It seems like Brennan has gone with like a lot of yellow cottage tail stuff that he's been saying is like leading now. This is stuff that Kevin's been saying, and Kate Peter, all these people have been saying this crazy stuff, and it seems like everywhere Brennan goes, he's leading with their conspiracy theories. And I just wonder if this is true. There's no actual text messages. Well, how does that come back to Brennan at all?
Well, in the first instance, in terms of blowing up in his face, if it turns out that there are no communications, the troubling part is to file a motion like that. When you look at an email like this, and 2 of the names that should stick out on the email are Adam Lally and Laura McLaughlin, who also signed that motion, I believe. Not sure off the top of my head, but they generally sign in triplicate, right? And we all know that, one all for one and one for all in that courtroom, to the point where the defense attorneys have previously been admonished for not doing this. So if this motion were filed and they had actual knowledge that there are no communications between lawyer and client, that certainly would seem to be a very bad look. Practically speaking, if it is true that there are no text communications and there are no other communications, and certainly one way to respond to this potentially would be an affidavit from someone like David saying there are no messages and there are no communications in that time period. And, to the extent that we had conversations, lawyer and client back then, I'm talking just face to face, I have no specific recollection of this or that ought to be enough to knock this out completely. Now, again, I don't know what's there and what's not there, but if that email is suggesting there are no communications, Now, what if there's emails? I mean, again, I don't know. But the other issue, of course, is you have to be careful what you ask for the DA, because by their own witnesses' testimony, that's former trooper Michael Proctor, that phone was taken on the afternoon of January 29th. It was purportedly placed in airplane mode and not used for some time period after that. And if that were the case, then as of January 29th, at whatever time he sees the phone, if it's in airplane mode, right, it's not on Wi-Fi, and they haven't tinkered with it in any way, then the data should be only up to that point. In other words, if there were communications later, they wouldn't sync up. But if there's nothing on January 29th, and certainly there can't be on January 30th, 31st, because her phone wasn't in her possession, then, they've got some splaining to do, as they say. And if it turns out that there are communications, then how does Proctor, assuming he testifies at all, explain that inconsistency?
Do you think there are? Do you have any reason to believe there might be?
I have no idea what's on the phone or what was said or anything, other than the trial record indicates that on January 29th, the phone was seized without a warrant, which is a whole nother issue that to this day, I don't understand how that happened, but whatever. What's done is done at this point. They took the phone when they went to her parents' house. I mean, they took the phone in the car, both without warrants. So at that point on, how is she sending text messages from her phone? Unless, are they saying she used another phone? Again, if they're searching her phone back then, even if she was using another phone, you wouldn't see it because they had her phone. So, and that based on the email you put on the screen, that appears to suggest, at least the way it's written, that there might have been some communications with another lawyer who, that privilege would not be breached as it relates to him. And that they certainly have no right to look at that. So this is an interesting email. Again, don't know what it means without knowing the full story, but one wonders whether the other two prosecutors shared this information with Brennan before he, in my view, very cavalierly sought to pierce what is the most, and what he certainly knows, he's been a defense attorney for 20 years, the most sacrosanct thing in our profession. I mean, attorney-client privilege. And I just can't help but wonder how he goes back to private practice when this is over and the clients think that you're so willing to break up that on these apparent, Mickey Mouse interviews that she gave, ill-advised or otherwise, as a basis to pounce and say, I get to see everything. That's probably not good for business going forward when you're in private practice.
With this motion to put them on the stand, how likely do you think Judge Canone will actually go for this? She's not going to go for it, right? I feel like she won't go for it because she wants April 1st. And if she does go for it, it's going to delay the trial. How long do you think it would get delayed for?
Well, I don't think she's going to go for this concept of calling. Don't forget, the other lawyers are on the list too, at least the lawyers who were involved in the interviews. So I don't think she's going to go for that because that's just ridiculous. It's not necessary. And obviously the court will favor not making the lawyers delay the trial. So I don't think that's a relevant issue. That has no merit. The only one of these issues that even has any legal merit doesn't mean I would allow it. But I mean, the privilege argument, it's not frivolous. It's not literally frivolous. I mean, she did say on camera about statements and alluded to a conversation with a lawyer. And in theory, that could violate privilege to some extent, in theory. But again, if you allow it based on such a ticky-tack thing and allow the draconian and dramatic remedy of just blowing up their conversations within, the first couple of hours to first couple of days, after this incident in a purely speculative way, by the way. If the judge took that seriously and thought that there were communications that had to be disclosed, that could potentially make David a defense witness, in the sense that he may be necessary to defend and put in context what they're going to try to argue it says, because he's a fact witness to this. So that would require the judge to potentially dismiss one lawyer who is also the sponsoring attorney for the other attorneys. And if these lawyers were to actually be witnesses and testify, or the real possibility, I mean, how are you not talking about a delay of at least 3, probably 6 months, based upon what kind of case this is? Nobody wants that. Certainly the judge doesn't want that. That's for sure. Defense doesn't want that. Obviously they want their legal team in place. So, what is she going to do? I've learned to stop making predictions what the judge is going to do with some of these motions in this case, but I think it would be virtually unprecedented in a murder case a week before trial to address this issue and possibly blow the whole thing up, because there may have been a conversation between lawyer and client that may have talked about the possibility of, what if I hit someone? And in any event, the point that I keep coming back to is, this is a strange topic to go all in on a week before trial, to risk even potentially blowing it up when it's really not a big deal either way. I mean, there's already evidence of, did I hit him? I hit him. It's not new. And in any event, that's going to be litigated at the trial. There are many explanations that even if she thought she did hit him or could have hit him, given her state of mind at the time, I mean, how persuasive is that when the scientific evidence, at least through some of these witnesses, tends to establish through science that she didn't hit him? And I think most rational finders of fact would credit science, unemotional testimony over a woman in a complete state. I mean, literally, they sectioned her, literally in a state of, emotional distress, who doesn't know what's going on, can't remember this, does that, doesn't know this, screaming, yelling, and says, what if I hit him? What if I did this? I mean, if you credit that more than sober science, then that's not how it works. And that's generally not what I would call the most persuasive evidence. And in any event, whatever conversations were happening on January 29th between lawyer and client, whatever they may or may not have been, who knows? That's still fresh, when she's getting over the excitement of it, trying to figure out what's going on. And it just seems like a very draconian fishing expedition. And it just seems so over aggressive. And it seems just that this is a win at all cost, no matter what, and without regard to your professional reputation, which is very interesting, because this guy is not a DA in the office. Presumably he's going to go back to private practice. And just these kinds of tactics, I don't know that they sit well with a lot of people who are just watching this, whatever they think about Karen's guilt or non-guilt.
Definitely not. I think a lot of attorneys are having questions about it. It's putting attorneys on the stand.
Well,
a week before like this, just wild.
You've heard this. I mean, I've used this expression many times, and it applies again and again with the way they prosecute this case. Just because they can doesn't mean they should. I mean, it's the same way with the murder count. Even if they're allowed to do it, why in the hell would you do it? I mean, the idea that this is a murder case is, it's silly. It's not silly in a factual sense. Man lost his life somehow, some way. But in a legal exercise, it's silly to believe that, after a night of, hanging out, being lovey-dovey, she developed the intent to kill him by mowing him down in front of a house full of 15 people and a whole bunch of neighbors, and then decided to tell everyone a couple hours later, I crack my taillight and I hit him, and I need to go back to the scene, and there he is. None of this makes any sense in terms of an intentional killing and her conduct after. I mean, if you believe that she backed into the Traverse on purpose, left all those voicemails on purpose, did all these. I mean, if that's the case, she would be the dumbest murderer in history, or close to it.
Yeah, especially the voicemails. The voicemails are just nobody would do that. They would call and say, "Honey, where are you? I thought you were going to be home, honey." That's what they'd be saying.
I would say dumbest, but in actuality, she wouldn't even be the dumbest in Norfolk County. That would still probably go to this Walsh guy, based on his.
Yeah, he's pretty dumb for the searches and the. Yeah, Walsh is he's not a mastermind. His art theft too was pretty low. Like
I forgot actually. When he got arrested, I had given an interview about him in the New York Post. This is before I knew anything, who you were, or who Karen was, or anything, and called him dumb as dirt at the time. I'm like, oh yeah, that seems to fit. It's still out there online. It's kind of a funny article, but I mean, it was about his internet searches. Yeah.
You think about these things ahead of time, or do you just come up with them? Because you have a lot of Bederowisms.
No. I was driving around and got a call from a reporter about this, wacky case in Massachusetts, and this guy who allegedly just, did a full stream of conscience on his, daughter's iPad or whatever it was, and literally about like how to commit a murder, how to cover up a murder, how to dispose of a body, and what just came out was, that's you have to be as dumb as.
That was dirt. I love it. It's true. That is pretty dumb. I mean, yeah, especially today. Like, it's not like one thing if it was 1999 and people hadn't caught on yet, but like 2025, you're still doing that kind of dumb shit.
Yeah, I mean, look, the Norfolk DA State Police, they found all the evidence. So
yeah, they did on that one. They did on that one. When it wasn't one of their friends. When it. That's the point on the list. It's so I just want to ask, like, let's say the judge is crazy enough to actually say, all right, you guys we're putting you all on the stand. How long would that delay her defense in the trial? Like, how many months do you think it would take?
Well, if she had to get all new attorneys, I mean, look at the amount of evidence and craziness and witnesses and all of this stuff going on. I mean, how could somebody coming in brand new need less than 4, 5, 6 months? I mean, it's not exactly a petty larceny, stealing a pack of gum from the bodega kind of case. It's a little more complicated than that, and there's just a hell of a lot going on. So,
related to that, Glamis Shoes says if it gets delayed past July 1st, isn't it dismissed? Is that correct? Like on retrials, is there like a set time that you have to do a retrial?
I believe there's another one of these archaic, perhaps even convoluted Massachusetts rules that speaks to that. I would have to imagine, though, and again, I'm not a Massachusetts procedure expert, so if this is not accurate, I would imagine there are circumstances that would allow for that time to be told or waived. I mean, look, if there were delays that were not literally the fault of the prosecution's ability to bring a case to trial, it would be absurd, being fair, not to this case, in any case, to dismiss it. I mean, suppose you had a situation where on this case, all the defense lawyers got terminally ill or sick or something terrible, and then now they can't try the case before July 1st. I mean, that case doesn't get dismissed. How could that case get dismissed for something that's clearly not the prosecution's fault? I think that rule is set in place to say you can't just drag your feet and leave somebody in legal jeopardy in perpetuity. You have a right to a fair trial sooner than later. But I don't think that kind of situation. I mean, I'll give you another example. The defense is still seeking a stay because of the federal court. I mean, if that were to take months, that's not going to dismiss the state case. So I have to believe that there are exceptions that are built in that would allow July 1 to have extensions as long as there's not deliberate delay or something that's, unforeseen.
To that, a more of a Lessie level of a Lessie says, why does Judge C care so much about trial date?
Well, if you start on April 1st, it's roughly 2-month trial, roughly. That would take you to June. A lot of people don't like summer trials. I mean, that's everywhere, especially in that courtroom, right? How hot it is, and the fan and the whatever. But, I can't speak to that other than there does appear to be this hyper focus on April 1st that appears to control a lot of things, which I think is unfortunate. Like, for example, there's a motion to dismiss that's pending. Today is March 24th. It's a week away. Obviously there won't be an evidentiary hearing when there very well should be in that motion to dismiss. That there has to be a decision before April 1st, and we're still talking about jury notices and this. So without being told, you've been told that the motion to dismiss is going to be denied without a hearing. And I think that you couldn't be more inaccurate in doing that without the hearing, because there are real issues that have to be fleshed out, including on the issue of whether there's intentional misconduct. And that really requires Proctor, since he's become the patsy, to testify. It really requires the testimony of the sergeant with the long last name who retired from the Canton Police. It requires Lally and McLaughlin. I mean, a judge ought to drill down and say, am I really going to find that the prosecution had no idea for 2 years what was going on with the video? And then ask the other difficult questions, which is, once you did learn about the video, why the hell did you disclose it in piecemeal fashion before, during, and after trial? I mean, these are kind of important questions to whether there was intentional misconduct that appear to have just seemingly have been ignored, are going to be swept under the rug and not addressed.
Outrageous. That's outrageous that's not going to be even considered. And April 1st, I mean, one of the things she keeps talking about is what you said, the jury notices have gone out. It's a cost. It's like,
I don't care about cost.
Yeah.
I care about a defendant's due process right to a fair trial. And if that inconveniences the state and the jury notices and the bureaucratic cost, well, that's a price you pay when you have somebody who has said that I'm not guilty, asserted their innocence and intends to hold you to the burden of proof. I mean, in a trial, a defendant's right to due process has to come first, above and beyond anything else. And, I think what you're going to see, by the way, on the motion to dismiss, there's only one real way, if you're going to deny this, to do it. I think what you're going to see is some gentle criticism of the police. It will presumably not be intentional. It's just one of those things that happen. The evidence will show that the prosecution was unaware. That's actually not true. There is no evidence that was submitted no sworn evidence, no real evidence submitted by the prosecution in return. But I think ultimately what the judge will say is, assuming arguendo that, there was a violation and all these things, that it wasn't material and it had no impact on the outcome, of the trial. And that's troubling because, there's reason to believe that 2 of these counts were very heavily acquittals, if not outright acquittals. And if the video had been disclosed properly, that could have affected the outcome. The other thing is this, and I'm not sure the defense argued in this way, but if the defense had known that they only got partial video during the trial, if they had known that during the trial, they could have had a field day with that issue. And how do you think that would play in front of the jury? So it's not just the evidentiary value of the video itself, it's the way this played out. I mean, we now know that they did not disclose video and that Proctor held it for 2 years, according to them. If the jury in the first case knew that, knowing everything else they knew about Michael Proctor, and knew that there was video that was not disclosed, and knew that some of the undisclosed video included Brian Higgins on his phone doing whatever, how might that have possibly impacted the outcome? So, I mean, I've done a lot of these hearings on whether they're motions to dismiss, pretrial, or post-conviction Brady type hearings, and how this case doesn't have a hearing on this is, it's unbelievable to me. And if there was a hearing, it would take a long time. I mean, you're talking 10 to 15 witnesses that if I'm the defense attorney, I'm calling. But that's clearly not happening because we have April 1st for trial. So
this really is. Let's ask some other questions here. Kevin keeps on harping. Kevin from Yellow Cottage. I usually don't mention him, but I figured I'd ask a question for Kevin tonight since Brennan is now like using Kevin's stuff. I figure like one of the Kevin's things is he says and I'm also going to play some video too about this in a minute, but how unusual is it for a U.S. attorney to actually question witnesses before a grand jury? Is that like really unusual? Does that show any type of collusion between Karen Read and the U.S. attorney?
And when you say the U.S. attorney, do you mean the person, the United States attorney, or the U.S. attorney's office?
The actual U.S. attorney, which was what was his name? Josh Levy. So how unusual is it for like a Levy be actually asking the questions of the witnesses before a grand jury?
It's unusual. Generally speaking, prosecutors, state and federal, but certainly federal, with the exception of, some rural county in Mississippi where the DA's office has like 2 lawyers or even 1 lawyer. So you might have the district attorney himself like try cases and things like that, with rare exception, but certainly almost never in a federal system where the U.S. attorney is absolutely a political appointee, an administrator, the figurehead, the boss man or boss lady, however you want to call it. For them to actually partake directly in litigation is extraordinarily rare. It's not rare for them to go to court every now and then and watch something, but to actually partake in questioning witnesses and do things like that, it's extraordinarily rare.
Well, Kevin comes up with that shows there's collusion between Karen and the U.S. attorney, and I just look at it and think maybe it's because the U.S. attorney knows this is such a big case that he felt like he wanted to personally get involved in it. It's such a sensitive topic. That's what I was thinking. But Kevin jumps to that Karen and the U.S. attorney are in collusion with each other, that he's working for Karen Read. What do you think about that?
I would suggest to people who are interested in learning how criminal procedure works and how federal grand jury practice works or other things, not get your advice from a guy like that. I mean, he has no experience in criminal law. He's never been a lawyer except for one time playing on YouTube, giving a summation before the case was over. And the reality is this, okay? The fact that the U.S. attorney was or was not present during any questioning is not significant to the idea of whether they're colluding or not, because the FBI investigated witnesses. They interviewed witnesses. Witnesses testified. Other prosecutors were involved in this investigation. So this is not a hip pocket investigation by the U.S. attorney by himself. This was a Department of Justice, which entails the FBI and U.S. attorney for the District of Massachusetts, combined investigation, which led wherever it led. But his theory, which is stupid, but it would only make sense if you had a rogue U.S. attorney doing a hip pocket private investigation. That's clearly not the case. No one in the U.S. attorney's office or the FBI was hiding the fact that this was happening. Indeed, there were letters going back and forth with the Norfolk DA whining to Washington, D.C., to the Office of Professional Responsibility, whining about it. And one of the highest ranking people at Justice in D.C. responding, saying, we trust our people in the District of Massachusetts and disagree with you. Okay, the man is an idiot. He should not be listened to about this kind of stuff. If he had any experience or credibility in criminal law, criminal procedure, or criminal practice, I get it. But, you know, if somebody's whispering nonsense into his ear just because he spouts it and spews it on YouTube doesn't make it so, okay? Find a lawyer that's partial to the other side and ask them. And if they want to tell you that that means anything, you can at least listen to it. But on this issue, they're not going to do it because they're going to value their reputation and credibility as lawyers first and thinking Karen's guilty second.
Except for one. I think there's one out there that's doing it. Like, it's so funny because, like, Kevin's been saying this shit for a long time. And I think he found one lawyer that actually does, like, want to lead with it. And his name's Hank Brennan. It seems like that this is, like, it's funny because it seems like Hank Brennan is running with this now. Like, that he actually believes that.
Listen,
and that's, like, out of his angle.
I mean, Brennan, I mean, look, he has a history with the FBI, obviously, from another case that he tried. And, you know, everyone's familiar with his public statements about, you know, you can't prosecute someone fairly if the police are lying or doing things. And you just change it from that case, from the FBI to the state police, and apparently, you know, no one's doing anything. I mean, look, lawyers take positions, they argue positions. That's what you do. But for a credentialed lawyer with a straight face to buy into a theory that Karen Reed, presumably guilty of murder in this hypothetical, or guilty of something, right, said to her lawyers, I've got a great idea, or her lawyers, whoever, will take the guilty people and we'll go to the U.S. attorney because he's just a corrupt buffoon and we'll want you to get away with this. And what we'll do is we'll ask him to interview all these people and prove that they're corrupt. And then what they'll do is they'll hire these ARCA guys. And not only will we find all these people corrupt, but we'll make sure we help you in the state case by proving that you're not guilty, because what's going to happen is after the trial, you're going to cut them a check for $20,000 to reimburse them for their travel. I mean, these are not serious people and they should be ignored. I mean, the people that are spouting this nonsense online are not serious people. Now, Brennan is, and you can't ignore it. And for him to embrace these, you know, these theories,
that's crazy.
And to suggest that there's some predetermined relationship between the alleged killer and the United States Attorney's Office, I mean, that's regrettable and unfortunate. And again, it's just the kind of stuff that as a lawyer, your number one stock and trade is your credibility. And I don't know why you would die on that hill. Now, again, they're going to do anything they can to discredit the ARCA people. And it's pretty obvious why, because, you know, you may think Brennan is many things. One of them is not stupid. Okay. He's not. And if you think he is, you're wrong. He's not stupid. He's tried a lot of cases. He's run a lot of investigations. He's smart enough to know that if the jury finds the ARCA guys credible, it's over on a reasonable doubt standard. That's always been the case. So you have to do whatever you can to attempt to discredit them. There are not many great ways to do it because, you know, other than saying the feds are corrupt. If the feds are corrupt, you know, he's trying to add some argument that by definition, the whole ARCA thing is a fix. That is probably the dumbest argument they've made throughout this case. And that's saying a lot because, you know, there's been a few.
We got a good comment from K-Wag, says, lawyer, you know, and his dad did a video breaking the Fed stuff down. Attic is wrong. I have that video queued up. I've had the video queued up for tonight. Let's play this. I want to see what you think. I think this is a funny video related to all this about Brennan, and I think like Kevin is Brennan's writer on
not
this,
some
so
nefarious collusion between the United States government and this defense team. Like, that's the thing that's so mind-boggling about how he's trying to explain this to Judge Cannoni. And it's like, this looks bad for you. It looks, because usually the state and federal prosecutors can work together if they have some kind of parallel investigation into the bad guy.
And that's why, again, this is a good time to just say it, but there are 94 federal districts in the country.
Go ahead. You can give the explanation now. We're going to listen to more of this, but you can give the explanation now.
Those 94 federal districts all have state prosecutors in there, as well as the U.S. attorney, the federal prosecutor. It is normal for them to all have lunch together, for all of them to, get together because they share investigations. The state prosecutors sometimes will give cases to the feds because they think the feds can handle it better. The feds will give cases to the state because they think the state can handle it better. They're usually like this all over the country. In Tampa, where, our office, we would regularly meet with the state attorney's office. We had no conflicts with the state attorney's office. Something's going on in the federal district in Massachusetts for them to have such distrust, such a conflict. The investigation might have been closed, but what he's saying exhibits something that is so rare in the country, where there is a conflict between the U.S. attorney's office and local state prosecutors. That just doesn't work for the benefit of the people of that district. That works to their detriment. And that's why you don't see it happening very much. He's admitting a real problem in Massachusetts.
And so many times, just like you, people go from being a state prosecutor in the middle district.
What do you think about that, Attorney Bederow?
So I agree with almost all of it. And I think any serious lawyer who's been doing this criminal practice would agree. I mean, because it's just obvious. There are situations where a federal prosecutor and state prosecutor can have a rivalry. Okay, New York is the best example. Okay, the U.S. attorney for the Southern District of New York, which they call themselves the Sovereign District of New York. That's kind of the disparaging term that others use for them. And the Manhattan DA have historically, because the Manhattan DA is one of the few state prosecutors' offices in the country that delves into white collar business, Wall Street kind of crime. And so there's some rivalry because they overlap in jurisdiction. They have Manhattan, they have all that, and they sometimes will lobby for cases. And even recently, you've seen it with this Mangione guy. They both charged him, and then the feds jumped in and charged him first. So that's rivalry, okay? That's not open hostility and one investigating alleged crimes potentially committed by the other, okay? There is never a situation in any case in New York City, whether you be a target of the Manhattan DA or the U.S. attorney, that, lawyers would get up, a prosecutor, would get up from the Manhattan DA's office and say, the defendant is colluding with the United States attorney. That would be front page New York Post absurdity around here, okay? And I don't know why this isn't a bigger deal in this case. The reason probably is because every day there's just more and more nonsense, and each absurdity gets outclassed by the next, literally in real time. But no, I agree with everything he's saying. Of course, it's ridiculous. They're supposed to work together, cooperate, and you have the state prosecutor in, the biggest murder case in the country, or one of them anyway, openly accusing the federal district in which Massachusetts sits, colluding with a murder defendant. That alone tells you the position of weakness that this prosecution is coming from. They are fully prepared with a straight face to whine to a jury that this is the case and this makes ARCA corrupt and all of this. They are losing. If you're making, that is a loser argument that you're making a week before trial. That is a desperate argument. That is a stupid argument. And ultimately, it's an argument that is going to go absolutely nowhere and blow up in their face, because these doctors from ARCA are going to come in and they're going to say, I got hired by the Justice Department. I don't know who the hell Karen Reed was then. I don't know who you are, Hank Brennan. I don't know who these prosecutors are. I don't know anything. I just went on to do a scientific evaluation, okay? So if you want to cross-examine them and have any chance at all, ready for this? Do it the Lally way. See, I said it. Do it the Lally way. At least he tried to suggest well, you didn't have this, you didn't have that. Now, they ultimately said it doesn't make a difference because the science is the science. I don't care about your glass fragments because the science doesn't fit. But the argument that Brennan makes is a loser, okay? That is a loser argument for a losing case, and no one will take that seriously.
Absolutely. And I fortunately I didn't actually get the clip up. I thought I did, but it gets better there with Peter and his dad. They literally are laughing at Brennan about this whole thing and laughing at the DA's office. They're just like having a grand old time laughing at him like it's preposterous.
The reason they're laughing, no, that was Winnie, not Lola barking in the comment I just looked at. But anybody who is a lawyer who, again, is a criminal practitioner and does this for a living, whether it's New York, Massachusetts, Timbuktu, anywhere, would recognize that for the prosecutor to get up and tell the court we're going to be arguing and suggesting that the defense is, in essence, conspiring, colluding with the U.S. attorney himself. I mean, that's just pathetic. That is the moment where you should pack up your bag and go home. You got to do better than that. Okay, if you have the science, argue the science. Well, obviously they're terrified of the, and rightfully so, of what the ARCA science is. You saw the effort they made to keep them out. They don't have much to do with them. I mean, they're going to try to cross-examine these witnesses and suggest to the jury that because they got paid travel expenses reimbursed after trial, by the way, after the first trial, that somehow is some form of motive for them to fabricate their testimony at trial when all they're doing is regurgitating the opinion they gave months before they ever knew who anyone on the defense was. These are loser arguments made by the losing side.
Buddy, about a couple of weeks ago, I got mad at a caller because they brought up Kevin. I don't want to talk about Kevin, but I unblocked him recently and I watched one of his videos and I was shocked by what they were doing. And one of the guest statements, I think it was last night, actually. KP has recently put out this whole long video calling the Free Karen Reed people grifters and making accusations that Karen pays for protesters to show up, while KP shows videos of people that we all know, all the locals that show up, all of our friends.
Defamatory, depending on the basis for that statement and how she's. But that's for somebody to worry about.
And then on this episode, Kevin tried to pile on that and basically try to say that again, people being paid, but that PR firms are actually hiring us YouTubers to sow the narrative for Karen, and we're not disclosing it, and that we're being corrupt, which has never happened here. No PR firm has ever reached out to me. Nobody's offered me a payment to change anything I say on the show. Never happened, as far as I know, to any Free Karen Reed person. But this guy, Matt, millennial, actually says he believes it's happening because he actually did it. He had a PR firm reach out to him on another case, apparently. And he actually took a payment. If I'm listening, if my ears are hearing this correctly, he took a payment and didn't disclose it to the audience. Wicked shady. These are the folks. Let's play the clip. This is, to me, just wild. When I saw this clip yesterday, I was like, holy shit.
The Fantastic Four.
Different cases where they're like, oh, can you make a video for this much money? So I absolutely.
Oh, I want to hear about that. I'm very interested. Go ahead, please. I want to hear any details on that. That'll be really good.
I can't say the name of the company, but in general, it was something that I was already talking about, and I was already on the same side that they wanted me to be on. So they're like, oh, can you put out a video? You talked about this last year. We want people to start talking about this again. And I said, sure. I already had videos, so put it out. Get paid. You can't talk about it. Different cases where they're like, oh, can you make a video for this much money? So
Did you hear that? Did you hear that?
I'm pretty sure I heard it rationalized in the sense of, well, I already agreed with them and I already made the videos. The only difference is the PR firm wanted to use them and paid me for that privilege. And then, of course, said, but don't tell anyone.
Don't tell anyone. That's shady to me.
Well, that qualifies if you're going to attack and make potentially defamatory claims with no basis to do so. Number one, if you live in a glass house, you know the old adage, be careful what you throw. But who watches that stuff? I mean, I don't know why that's even interesting. They're not providing anything useful other than saying it happens. And I've done it, and I don't know who that guy is, and I don't really care, and I'm not accusing him of doing anything. He may be a nice guy. I don't know. But the fact of the matter is, if they don't have any proof that anyone that they disagree with is doing that, and to throw that out there and to discuss it during a show, and one of your panelists says, well, yeah, I've done that, that's pretty amateur hour.
Wild. It could be a crime too. I mean, I don't know. I think you would have to disclose.
I don't.
By the law now, you have to disclose if you're being sponsored by somebody.
I don't think it's a crime. I mean, it can be sleazy depending on how it's concealed and what is said. I mean, I don't think someone should get arrested for it. But
yeah, no, but I think you get fined. I think the FTC actually does come after YouTubers for that. Actually,
and, that's not my bailiwick, so I don't know. But the point is, if they're gonna have this attempt to humiliate and accuse people of things, you might want to screen what people are going to say on your behalf beforehand. That's all.
DUI guy says during the Johnny Depp trial, the Amber Heard's stance did the same thing to us, accused us of being grifters and paid actors for Johnny's payroll, the hallmark of the losing camp.
Well, I mean, yeah. I mean, look, if they have online people attacking supporters, what's the point? What is the goal there? Is this to drown out support? I don't know. I don't really care. I mean, from a lawyer's perspective, you're just looking at the evidence and trying to determine whether, you think somebody is guilty or not guilty. What the purpose of that Fantastic Four is to run around accusing people of ginning up numbers when at least one of them has done it in the past. I mean, I don't know what that accomplishes. It's just needling, it's poking, it's provoking. To me, it's all nonsense. It's not worth more than the 30 seconds of attention to wipe it off the bottom of your shoe and move on.
Right. AV to the seventh power. Oh my God. I watch her. She's awesome. Actually, she's very, I was just actually watching AV. It's funny what she's posting this, because I was thinking that I want to have you on the show. Actually, AV to the seventh power. We have similar minds here. She says, great coverage, Mike and Mark. Spot on. Would love to chat with you both on stream soon. 61,000. That's her following on YouTube. Boston legal creator. I would love to have you on. I don't know. Have you seen her yet? Have you noticed her?
No, I mean, I see there's an invite there, but yeah.
She's phenomenal. You got to check her out. Yeah. I like her. She's an attorney too. So, I mean, it's, and she's a local too. And she just, I just noticed her covering Karen Reed. She covers a lot of other stuff too. Hank Morrissey, Canoni says, why should Hank say that the defense is colluding with FBI and then say FBI called CPD, Norfolk County District Attorney's Office and Mass State Police to say the investigation is over? Makes no sense.
Well, I think a lot of things about this prosecution make no sense. And I think whatever they have at any given moment that they think is helpful to put out there, they do. I mean, I agree. If they're colluding with the other side, they're telling you it's over. They don't have to do that. In fact, it's not common for an investigation that never really leads to anything for the feds to notify people involved. Now, again, it's a public corruption investigation. It involves law enforcement. There had been a lot of public discussion about it. So I don't fault the U.S. attorney for letting people know who were involved that nothing's happening. That doesn't bother me just as a lawyer, putting aside the facts of this case. But it does appear inconsistent with this, collusion, if you will, that they would go out of their way to let them know. But when you say it makes no sense, nothing makes sense here, really. That or a lot of things. doing don't make sense. And that is a problem when you're the party with the burden of proof. You know, you have the obligation here, and you're really just throwing mud at the wall and seeing what can stick. And that's just not going to result in a conviction. You have to do better than that.
Team Wicked Smart versus Pure Wicked says, I somehow keep forgetting the 2 blood drops of 2 unidentified males on Officer John O'Keefe's jeans. Thoughts on necessity of hearing this vital evidence at retrial? We've talked about this in the past, right? The two different males.
It's important, I guess, for a couple of reasons. I mean, number one, the problem is there was an insufficient concentration to even test it. So in term, other than it's not John O'Keefe, which, by the way, can have evidentiary value. The fact that there's 2 other people admittedly unidentified and not even able to be identified due to the low quantity of DNA. But it's certainly fair to suggest if you got hit by a car and just went flying and landed there, you know, why is there blood on him? Now, who knows? You know, you could get, if it's that small, you could get blood in any number of ways. I mean, I wouldn't overstate it. You know, it's not the same way the DNA on the back of the taillight, which is just touch DNA of John O'Keefe. You know, that's not a big deal either, because, you know, that's his girlfriend's vehicle and he's going to touch it. You know, you're going to empty groceries, you're going to whatever. The fact that there could be basic touch DNA, which is really just your hands, your body, whatever, it's not that compelling. So I would point out that there was blood. I don't know how compelling that is. I think what's more important is all the vomit going down and where all the blood and other stuff is, given the way he landed and how it all got where it did, how it got on the bottom of his shoe, if I recall. That seems more problematic for the way the prosecution, at least the first time, tried to suggest that the accident happened. I mean, I don't know how the vomit goes, you know, all the way down the chest into the underwear if you're lying, you know, on your back.
This FBI agent, Michael Easter, who's going to be for the defense, he's the defense expert witness. He wants to talk about policy, procedure, investigation, standards. Brennan's pushing back, and the judge too. Like, seems like she feels like she needs some type of legal backup on this. To me, it seems like it shouldn't even be needed. There's been a lot of discussion online about this. What do you think? Like, what's going on there with the FBI agent? Is he going to be allowed to testify?
He ought to be. I mean, look, if she wants more legal support, then the answer is you just go get it. I mean, look, their defense is, amongst other things, that this was such a shitty police investigation, whether it be incompetent, corrupt, a little bit of both, that their dreadful investigation in this case leads to reasonable doubt. You know, the so-called Bowden defense, as they call it. Okay. And you're allowed, certainly in Massachusetts, to have an expert, if you can meet the burden of using that defense, which they clearly can, explain any problems in the investigation through somebody who's competent to testify, which would really just be somebody with a lot of police type experience in securing crime scenes, doing things. And I mean, somebody ought to be able to testify about the significance of basic, you'd think things that would be so basic, such as, I don't know, secure a crime scene. That seems to be something that an expert can explain, that, you know, if they had secured the crime scene from beginning until the search team came, there'd be no planting of evidence. That would even be an option, right? Those taillight pieces would have to be there. They didn't do it. We talked about this before, not taking pictures of the vehicle when, you know, Proctor's testimony was, I was on my way down. I had already decided she had committed a hit and run. I had already ordered that car to be towed. In other words, I know that's the murder weapon, for lack of a better term, and he doesn't take a picture or evaluate the murder weapon. Would they ever do that in a shooting case? Would they not photograph the gun or whatever evidence?
Yeah,
Of
all the
course.
casings, everything. They put numbers by them. They do the whole.
Never, by his own testimony, if you believe him, he never went to 34 Fairview for 3 or 4 days. That's insane. The lead, in, I mean, if you believe it, I'm not sure I would believe that. So there are all these kinds of things. Those are just a few of these oddities that didn't occur in this case that an expert could explain were not done properly, and then pass the baton to the defense attorney to say, you know what, if these idiots had actually secured the crime scene, they might have an issue with the taillight. If they had actually, cared for all these other factors, if you had a picture of the taillight in the driveway of Karen's parents' house on January 29th, and you had metadata of that picture, and it looked like 3 days later in the Sally port, that's it. They couldn't have planted all those pieces that fit, but they didn't do any of that. So ought there be an expert allowed to do that? There should be. And I can assure you that, in any of these cases, I'm sure that Brennan tried as a defense attorney, he's making the exact opposite argument that he's making now, but the same argument if he was on the other side of the table. So they just don't want the jury to allow the defense to present a case. And that's un-American. Okay. They have every right to present their best case. They can argue that she's guilty, all of that. But it's still America, and she still has a right to, her attorneys of her choice to present arguments that support a finding of not guilty. And a lot of the stuff that's been going on back and forth in the past month, 2 months, has been more the prosecution playing defense on what they expect the defense to do than what they're actually going to prove. And that's just not how this works. The defendant gets a fair trial. Part of a fair trial is the right to present evidence that supports a finding of not guilty. And I've said this before, but it's worth repeating. Every time the prosecutor whines about their right to a fair trial as if it's equal to her right, it's not. It's absolutely not. There's a constitutional right for the defendant and just a general fairness right for the prosecution. They are entitled to be treated fairly. But to equate their right to a fair trial on the plane that a defendant's constitutional right is absolutely wrong, and no prosecutor should ever say that. And if they think like that, that's a red flag.
Really, I love that you said that, because it's so true. There's so many times that I feel like they're worried. The judge and especially the prosecution feel like they have more rights than Karen, which is not the way this country is supposed to be. The Constitution.
The Constitution protects individuals against government power, abuse, tyranny. It doesn't protect the government.
Exactly.
It doesn't work that way.
Yeah, it says it limits the government. It says you only have, this is where your power ends and the people's rights start. I mean,
there is a reason why the first 10 amendments, which are all individual rights, are called the Bill of Rights, is that because in order to ratify the Constitution in 1787 and to make the deal, that the Bill of Rights had to come with it. There had to be some protection to prevent tyranny and protect individuals that even the founding fathers knew all the way back then. And that's where this all comes from. Those 10 amendments, the Bill of Rights, protect individuals. Those are individual constitutional rights, not the Norfolk DA's right to a fair trial.
Bill Foster says, this is funny, would it be more efficient for the Commonwealth to have a wax statue of Lally made up and prop it up next to Brennan so the real Lally can go work on other cases? Well, then, I mean, I saw Brennan going like this at one point during the hearing, like he needed a water. So I think that's what Lally does. He goes and gets the water. So I don't think the wax statue could be the water boy.
It's one hell of a dynamic. One can only imagine what is really going on in all three. I mean, it's a weird dynamic.
Donna says, Attorney Bederow, why is no one talking about Brennan reading Morrissey's emails? Because he doesn't trust the taint team. Isn't that horribly wrong?
So I can't talk about Morrissey's or anyone else's emails for obvious reasons that I raised months and months ago about said emails and other things and other litigation So I can't talk about that.
Cheesy banana. I'll just say cheesy banana. That's it. I still can't get over that. He allegedly is using a cheesy banana email. Amy Z says, what's taking her so long to rule on the motion to dismiss? Incredible she wouldn't have a hearing before the trial based on all the info in the motion to dismiss. What do you think? Why is it taking so long if she's not having a hearing?
Well, it's hard. This is a hard decision to write, to basically deny without a hearing, if that's what it's going to be. And just based on the clock, it appears that's what it would be. You know, one of the principal arguments that the prosecution, not even arguments, one of the principal self-serving defenses that they've made, and I mean literally the prosecutors, okay, not the cops who are technically covered under Brady and Rule 14, their principal claim was a self-serving argument that we, literally the prosecutors, had no idea, didn't know, don't blame us, which is not a legal argument. So that's troubling in and of itself. But they also didn't really even attempt to account for why all the video wasn't disclosed once they learned. They just kind of ignored that. There is no explanation for what Proctor did, if that's what truly happened. There is no conclusion other than based on his history that he stuffed it in his back pocket. He would have a right to explain at a hearing what it was. So this is going to be tough to justify and just issue a decision that says, well, you know, they clearly had discoverable evidence they didn't disclose. For some reason, the now disgraced and terminated lead investigator, who, by the way, was found to have potentially had a bias against Karen. That was one of the specifications, that there was the appearance of a possible bias, which is the worst kind of cross-examination of anything. You know, the same guy with all those problems has no explanation for why none of this was turned over. The DA has no explanation other than we weren't told. It's a clear violation. It clearly would have been helpful to the defense. Again, as we talked about earlier, it clearly would have been helpful for the defense to argue that they are not turning over the video, or they didn't turn it over for 2 years. So she's going to have to say that all of this is presumably wrong, yet even if the jury knew all of it, it wouldn't have an impact on the outcome. And that's a tough decision to write.
Question, go back to our previous discussion. They ask, any case law for getting privileged comms due to partial disclosure? How much is waived?
Well,
From Auto Doctor.
It's tricky. I think it's noticeable that in the motion that they filed, they don't cite any case law for what it's worth. Now, they cite the general concept of, if you disclose a privileged conversation to a third party, and again, when I say they, it's got to be the client. The privilege belongs to the client, not the lawyer. That's important to recognize. That the subject matter related, now that's where the rub is. What does that mean? The subject matter of that communication could theoretically be deemed to be waived. Now, there was some video on this show where she mentioned a conversation with my lawyer, and I said, well, what if I did this? Or I'm paraphrasing if I'm wrong. I mean, if you were taking a law school exam in which you issue spot, you would say, yeah, that's a real issue about a possible waiver. The question becomes, what's the subject matter? And is this so serious, given the substance, the timing, everything else, the possible loss of attorneys right before trial, that the judge should say, well, I need to now see all this and decide if we're going to blow it up over the possibility that, you know, Karen said, well, I hit him. Who knows? But again, I expect the defense will come back with the January 29th testimony. And based on the email you showed us earlier, it appears that the DA was given notice of the existence of a privilege log, and that the log contained 2 communications with a different lawyer from that date. And, you know, that the defense, I assume, will argue that ought to settle it. And we'll have to see what she does. You're silenced.
Question for Mark. Can you discuss things after the case is concluded, or ever that you can not today, like the DA email that you couldn't answer just a second ago. That's NDD.
It really depends, but I mean, it's like so far in the future, it's not anything you even think about. But no, I mean, right now there are certain guardrails in place, and there are protective orders and all kinds of things that preclude discussion of certain things, and you have to respect those, and out of an abundance of caution, not get into it. So it's really just the way it is right now. It doesn't mean that will be in perpetuity.
This one came in. I'm looking up the name. Thought of you two the other day. This is from Legally Blonde. She says, found out my neighbor's brother-in-law is Joe Mazzulla. We live in the greater Cincinnati area now. Even sports talk brings me back to Karen Reed.
So Mazzulla's the Celtics coach.
Oh, is that what I'm missing?
Yeah,
I don't even know who the Celtics coach is.
I've done just a complete 180 on Mazzulla. I hated him the first year. I just thought he was so out of his depth and so socially awkward. And now I've just done a total 180. And I mean, the guy is a psycho, but he's our psycho. And you love that. I mean, everything about him he's so socially awkward and weird. And he used to run out, if you remember, trying to like block shots at timeouts of other players where even the league had to say, you can't do that. I mean, you're like the head coach of an NBA team. You can't be doing that. But I actually, now I love him.
I thought Doc Rivers was still the coach. I didn't even know. I remember there was another scandal with a coach. That's not him? That was another coach before Doc Rivers, maybe.
Udoka, who was.
Yeah, that's right. Yeah.
Things, with people involved in the organization he shouldn't have been doing. I mean, you're really dating yourself. Doc Rivers has been gone from the Celtics for like 12 years. Yeah. He did
how much I pay attention.
2008.
I was at my girlfriend's son's house, and he's got Jason Tatum sneakers. Have you seen those?
Yeah.
Yeah. I took a picture.
I've got a pair. I've got a pair of the pink lemonades.
You got so you have them too.
Yeah, they're like all pastel-y, pink, yellow, and green. They look like a great idea at the time, but now they just kind of sit on the shelf because they're a little wild. But yeah,
hilarious. A few more questions came in. A lot of questions actually. Here's one. Do we believe they found almost all the taillight busting for truth?
Well, I mean, I think the way they reassembled it, I think they are for the most part satisfied that all of the taillight just revealed itself over the course of a couple of weeks, and lucky them, they found most of it. I mean, that's the
kind of funny, isn't it? Yeah.
To me, that has always struck me as one of the most patently absurd components of this, which is only made that much stronger by the fact that the ARCA guys are going to say those taillight pieces mean nothing to me. It can't be. To me, that just segues so perfectly into, if the taillight didn't shatter in the way these people claim, then how the hell did it happen? Which only leads to one conclusion, somebody's sprinkling taillight or just holding it back and, finding it odd job style from Goldfinger, for those who know.
Here's a comment. Here we go. Regarding Lally's role, he did basically just point and say, read the binder, idiot, when Brennan asked him what the court's standard procedure was.
I don't know whose job is what. It's an interesting dynamic. Most interesting to me is, given the judge's tongue lashing of the defense for candor to the court and what she deems misstatements. There have been so many inaccurate statements by Brennan, virtually all of which Lally had to know at the time Brennan was saying them, that they're not accurate, and he had nothing to offer or correct. And apparently it just, things continue without comment after that. And it's, I don't know. That's kind of weird to me.
A septic tank off lie says, exactly, Stank has said how many times, if the defense does this, then I welcome ARCA. Yet he continues to try to find ways to make it so they are not allowed. He's so scared of ARCA.
It's all, I mean, look, it's all cliche and appearance and gobbledygook. They don't want ARCA, okay? They have for weeks and weeks been wrapping the ARCA issue around attempts to kick off lawyers, seek serious sanctions, exclude these witnesses who are the quintessential exculpatory witnesses. You cannot get more exculpatory than these people. It doesn't mean you have to believe them, but their testimony is literally kneecapping the DA's argument. I mean, they are literally saying it cannot be what you allege. That is as exculpatory gets. So this idea that I welcome ARCA, I mean, that's just lawyer talking out of both sides of your mouth. That's nonsense.
Does that a lot. Nina asked, was your client relationship really waiverable? If Turtle Boy would turn on Karen Reed, you couldn't represent both.
I obviously am not going to get into the specifics of this question. There was an affidavit that was filed publicly which outlines certain things. It's available. You can read it. That's all I'll say about that.
Perfect. Josh H says the Commonwealth is not ready to bring the case, but they can't dismiss it without looking like a rush to judgment.
They're not dismissing this case.
Yeah. DUI guy says, I'd love to interview Mark as well. I sent you a friend request. I think it's you.
Pretty sure I'm the only Mark Bederow that you'll ever find anywhere. But yeah.
Yeah. You're getting a lot of YouTubers on here that want to interview you. Of course. I mean, you must get a lot of requests. You're not flooded with requests at this point.
What, like Facebook stuff?
Or just people asking for the interviews because, you know, we've had two tonight. Two people have come up and they want to interview the DUI guy and yeah.
I mean, quite a few. I mean, for some reason, people are, interested in certain things I have to say, or they just want to hate watch.
For some reason.
Yeah.
A wristband ruler says, have you seen Carl Steinbeck's video on alibi evidence versus third party culprit? Very interesting. I haven't seen it.
No, I haven't.
Steinbeck, but love to check it out.
By the way, that's Lola, the one barking now. I think she took something and they're trying to get it away, and it's not going so well down the hall.
Lola and Winnie having fun today.
Yeah, no, they're up to no good, I'm sure. I don't know. I haven't seen this video, but to me, the idea of third-party culprit as a concept is way overblown, because the reality is the DA's position is that the cause and manner of death has to be her mowing down John O'Keefe, and the defense has a lot of evidence, ARCA, others, that didn't happen. And by definition, John O'Keefe was dead on the lawn. And if it wasn't from the car accident, well, how the hell did it happen? Somebody else, because he has injuries, it's not a natural death, right? He didn't just, wander in the snow. And so that means someone else had to have done it. So obviously their argument leads to a generic version of a third-party culprit. It wasn't her. They're just seeking the right to really hone in on these certain individuals, and we know who they are. But either way, they're going to be able to argue all the weird and oddities that occurred after, whether it's the butt dials, the Albert to Higgins butt dial back and forth. I've never seen a conversation of butt dials. That's the only one probably in recorded history where there's an actual communication by butt dial. You have this thing with Jennifer McCabe butt dialing allegedly 10 times while she's, looking for John O'Keefe. There is not a person who believes that, who's a serious person. I mean, there's no way that could happen. You have all those other text messages about tell him the guy never went in the house and all that stuff. The Asian house, if you will. Don't tell anyone, save it for tomorrow. And then you find out she goes to Lank's house. So there's a lot of stuff, whether it's technically considered a third-party culprit or not, that in essence, it's arguing somebody else did it.
The third-party culprit, it came up the other day where Yannetti said 3 names.
Mm-hmm.
And then they went to Sidebar. Did you read anything into that? Because people have been really, it kind of lit up Twitter. People really talking about this, what it meant in terms of him stating the three names and then going to sidebar. Anything that you want to?
No, I think he didn't want to publicly say, I'm assuming, I don't know, but didn't want to publicly outline what that evidence was. Jury pool, perhaps, doesn't want them to know, to have it flagged to them as much as it would be if it was publicly disseminated. I don't read into that too much.
There's a question I have a feeling you can't answer, even if you know.
One last kind of. After that, I didn't see this because I didn't watch it, but I'm told, right when they came back, Brennan got on his phone and started texting. I mean,
that was weird.
I don't know. I mean, I'm sure it had something to do with this, but it doesn't jump out at me as, that big a deal. I mean, he's communicating with people clearly about what's happening. That to me is just kind of like a false flag issue. I don't know. Maybe it's bad, but I think we're making too big a deal out of that.
Okay. He could be talking to a child care provider too. If he has kids, you never know. Yeah,
he could be texting his wife and saying, I'm going to be
what are we eating for dinner tonight?
I mean, honestly, we don't know.
Yeah, we don't know. Here's one that you probably don't know either. And if you do, you probably can't say, but I'll ask it. Does Mark have an opinion whether or not Chris Albert is the one that notified Lank about the juror that was dismissed, especially since we know he's recording people?
No, I mean, I don't have an opinion, and certainly I would be speculating. There are, as you know, there have been letters that are in the public realm concerned about wiretapping going on at his establishment. But in terms of that, I have no idea. I'm not going to speculate. I don't know. That's for other people to figure out. I have no clue.
Gotta find a couple more of these questions here. I want to make sure I get them in. Angie Wave says, thanks, M&M. Awesome discussion. I am concerned that Hank twisting context, misconstruing evidence, and ad-libbing will not be called out by the judge. Cannoni, could this clearly pave the way for an appeal?
Well, I mean, if you're talking about an appeal, that's not a happy ending for Karen, obviously. It's not good, but in terms of what he's doing, I mean, lawyers are always, documenting things that occur in the record as a possible point of appeal. If there are rulings they think that are biased or unfair, you can certainly, make that argument. That's not the strongest argument on appeal. I mean, complaining that the judge is biased and ruled against us is not a strong appeal.
Probably not. Amanda says, Mark, have you heard on the Sean Ellis case? There was a movie about this, trial 4. False conviction and cop death, same district. Curious about seeing similarities in Commonwealth law enforcement conduct. It wasn't the same district. It was actually Suffolk County, I believe, in Boston. But same state. What do you think about that? Do you know anything about? Have you seen the trial 4 documentary?
No, I've heard of it, but I don't know enough to compare and contrast that much.
In a way, it's similar because it's basically about a cop murder. And it seems like the wrong person got fingered, and there's a bigger story about the cop, and the cop was crooked. It's crazy. It's a wild story, and it went to 4th retrial. They never got to the 4th retrial, actually, but they were getting ready to do the 3rd retrial. It would have been the 4th trial, and charges got dismissed. Tibby Gardner says, Mark, could the 3 people named as third-party culprits ever be prosecuted if Karen is found not guilty?
I mean, it could be, but who's doing that? I mean, look, you shouldn't prosecute someone unless you are satisfied that there is compelling evidence of guilt, and you shouldn't just prosecute someone because you think they're guilty. You still need the evidence. And in fact, that would, at least based upon what's out there now, potentially be the same mistake as it stands right now to what they're doing to Karen, right? They think she's guilty, so they just say, the hell with it, let's go forward. whatever people think about the three named so-called third-party culprits, that's not evidence per se. If there's no quantifiable proof, because who did it, right? Are you ever going to know? It's highly speculative and highly unlikely. And I think the sad reality is that you're never going to find out what actually happened to John. It's just not. I don't think it's the way this is set up. It's not going to happen. Now, if Karen were convicted, there's going to be a segment of people who are going to say, well, we just found out everything. We're satisfied. That's that. But, obviously many people would be unsatisfied. And if she's not convicted, it still doesn't establish what did happen. And, in terms of, does that mean that these three people that were named would be prosecuted? Almost certainly not. Unless there's some dramatic evidence that comes to surface. I can't imagine why they would be.
Makes a interesting comment here. She says secret hearing to revoke Karen Reed bail. Question mark. She needs to attend every hearing. Did you see that they did this thing the other day?
Of course I saw it.
Involved your client.
It's actually the one time I wish to hell I had been there, actually. But I couldn't be there for those court appearances in that week. But I watched it. The only thing I'll say about it is this, because it does involve things that I have an interest in, obviously. That hearing related to seeking access to phone records of a third party not directly involved in the actual case. Okay, that hearing was in the case of the Commonwealth versus Karen Reed, in which they dragged another person in for their data. It's a Rule 17. These happen all the time. The case was Karen's case. She had every right to be there. Her lawyers had every right to be there. They had every right to sit there. They had every right to have the anger on their face that they had. That was her hearing. And for the prosecutor to say that they don't even have standing to sit at the table or be here, that was disgraceful. Okay? That just was absolutely ridiculous. It was petty. And you better believe that they had every right. They should have been noticed to be heard. And if nothing else, she has a right to attend any proceeding that's not sealed that involves her case. Full stop.
Flux related to that says, understand it can get ugly out there in the legal world, but isn't Brenning pushing the envelope? Wasn't some people refused to work with him after this?
It's not for me to say. He's doing it the way he wants to do it. It's not the way I would do it. It's not the way that many other people would do it. But, I'm not a Massachusetts lawyer, so it's not likely that we would be working. But I can tell you this, whether he's a defense attorney or not, right now you're a prosecutor and you have to wear a white hat. And the role is to seek justice, not a conviction. Now, it's very different when you represent a client where the role is to demonstrate, that your client's not guilty and, it's not the truth per se. One might wonder if these roles are getting confused, if his innie and his outie are getting, reintegrated. I don't know, for the severance people.
Question here. Were you shocked that the judge pushed back at AJ?
The other day?
Yes.
Nah, I thought the judge, he had pointed questions and wanted to know, why you here or what would you say? I'll think. And what did he do? He let them argue. Now, look, these lawyers are thick-skinned. They were zealously representing their client, and the judge wanted to know why they were there, who they were, and it was resolved. They sat at the table and they argued. So I don't want to make more out of it than it was with the judge. I think the concern is not notifying her in the first instance of a right that there was a legal proceeding under your case that could impact the evidence used against you.
A comment from Amber C. This keeps coming up tonight. The timeline. They're talking about the Commonwealth's moving timeline. And the fact that Karen, when she got back to John's house, it was recorded the time with the wireless in the house, in the garage as well. There was some, so they know what time Karen got back to John's house. Attorney Steinbeck's been bringing it up a lot, that this should be the key to her defense. Do you think that that should come up a lot, the timeline for Karen, knowing that they know the exact time she returned to John's house?
Well, it depends. I mean, if there's credible proof of connecting to a Wi-Fi, and my recollection is there was just this gratuitous comment by Guarino, I think, that was the case. I don't know how accurate or inaccurate or whatever it is, but if that's true and she is conclusively there, or at least close, whatever, again, the science is, you can pick up a Wi-Fi network from a little distance, not that much, but if you could create an area where she was, and it doesn't fit the timeline of what the DA says was the time of the impact and how long it got to be there, then you are getting into potential alibi territory. I mean, if you say, if the time occurred here, I couldn't have been there. That's what an alibi is. I was someplace else. It really, to me, depends on the exact timeline.
Jim says, the lawyer you know and father laughing isn't good enough. Brennan is unethical. Let's call a duck a duck. I mean, it's fun to have a laugh, too. I thought the laughter was appropriate, actually.
Suggesting that the federal government was colluding with a murder defendant to go after witnesses and the DA and was involved in essentially engaging these corrupt expert witnesses who work for the military, the National Hockey League, and all these other projects. And they just decided we're going to, do the DA on this, and that would, that'll learn them, and then high five each other on the way out.
Yeah.
I find that's pathetic.
Especially when it's a cop, too. Like, I don't think that they would have any.
That's a really good point.
Sympathy when it's a cop.
That's actually a really good point, that the U.S. attorney would be corrupt and fix a case such that there deliberately be an injustice to holding whoever's accountable, holding whoever's responsible for the murder of a police officer accountable. That's a hell of a theory, but that's just plain silly. And
what's the motive? Like, Karen's not like some powerful person, like a politician or like a CEO. You know what I mean? There's like
the motive
was a dean at a college. I mean, that's not really someone that has the political power or the currency to, like, why would this U.S. attorney go for it? Makes no sense.
Well, they wouldn't. Again, there's no reason to do that. The motive for the DA, would be very simple. ARCA is going to bury us, so we need to dirty it up. And again, those are traditionally defense tactics, not prosecutor tactics. Prosecutors are usually very sober, methodical. Here's the proof. I'm going to lay it out. We got him. He's actually trying to dirty up, muddy, confuse, cloud, do all those kinds of things, and is putting the defense in the position of going up to the foggy window, wiping it off so the jury can see clearly right through. So we're in bizarro world. And again, I just laugh because I feel like perhaps, Brennan's innie and outie are reintegrating. He's getting confused on what side he's supposed to be on.
It's a new one. Is innie and outie?
Mike, that's Severance. You got to watch Severance. That's.
I haven't watched it. I'm gonna have to watch that one. That's a good one. I like it. Lieutenant Pez defense attorney says, would it help if the defense consulted with the mass defense attorneys? Bar has happened in the YSL trial. This question's come up a couple times tonight.
Well, I mean, look,
especially about Easter too. I think they're referring to about Michael Easter, the FBI agent.
It depends on who you're talking about. I mean, there's a reason why that of the 4 lawyers that she has, 3 of them are from out of state, and had there been 5, 4 of them would have been out of state. This is a corruption claim. frame, if you will. Dirty cops, dirty prosecutor, just dirty everywhere. And, the question is, not every lawyer local is willing to sign up for that. There could be a lot of heat professionally. People, all those kinds of things. So it really is a lawyer by lawyer basis. There's plenty of defense attorneys in Massachusetts, I assume, who think this case is absurd, who would love to be involved. But yeah, look, David is a Massachusetts attorney, a very high skilled and experienced one. So, I think they know what they're doing in terms of, and if there's any Massachusetts issues, that's the expert.
Yeah, he's been around. He definitely knows who to call to, I'm sure. Mark, the Bowden defense says Karen Reed's team have to stick with one defense tactic and only one, or can it be more than one? And I'm going to follow up on that. I feel like they probably can, but is it sensible to have more than one defense tactic? That would be my.
Well, it depends. Yes, you can throw any from the defense. You can throw mud as long as there's a good faith basis and some evidence to support it. You can't argue. You can't do, like you see on South Park, the Chewbacca defense, right? You can't just get up there and ramble without any evidentiary support. That works on South Park, but not the real world. But you can do that.
The aliens did it. The aliens did it.
Yeah.
You can't say that. No.
Never forget that Chewbacca was a Wookiee. But you have to, if you're going to use multiple issues, you have to do it where they synchronize with each other. So like the Bowden goes with the third party culprit, goes with what the ARCA people are saying, that goes with the taillight being, it all has to flow naturally and logically. That's what skilled advocates do. So, you want it to just flow logically and be synchronized, and they're going to do that.
Oh, everyone has their little handles on YouTube, and a lot of them are, based on little parodies of what's going on in the trial. That one's Bev's biased beratements. This one's Lola the Good Dog. Lola the Good Dog says, isn't one expert missing? The butt dial expert. All those calls were butt dials. Prove it. Little Lola says hi to Lola Bederow.
I think what you're going to see is, if you have an iPhone, you have to move it. It lights up. Scroll up is 1. Then you have to either use your face or password is presumably 2. Then you're going to have to push the phone is 3. Then you're going to have to hit the, I think the word is manipulations, right? You're talking anywhere from 4 to 5 manipulations each time. So when you take like Jennifer McCabe's, this is literally, I'm not a statistician, but I would suggest to you, when you start making the 1 in whatever, it's kind of like what you're used to hearing when you hear DNA testimony, like 1 in 75 quintillion tuplet, whatever. This is crazy. There's no way that could happen. And you're not even getting into the whole leaving voicemails and things like that. So I don't know that you need an expert. I think you could literally walk someone through and realize it just doesn't make sense.
Kelly has a question. She wants to know if that little stunt that Brennan did, do you think it, by not calling her defense team, that he was trying to actually get her locked up and have her bail revoked? Do you think that Brennan was trying to do that?
No, because again, I think that would be so absurd and a bridge too far, no matter how aggressive you think they are, that he's going to somehow argue she didn't show up, and then all it's going to lead is the defense to say she had no notice. And no, I think not everything is literally like that. I don't. And there isn't a judge on the planet, all of them, that means, who would revoke her bail because a prosecutor said she had the temerity not to show up for a hearing that she was told wasn't even happening. No.
Mickey asked, do they have to prove Bowden defense? Just why not prove that they don't have enough evidence to convict Karen instead?
they don't have to prove a damn thing. That's the beauty of the defense. All they have to do is establish the existence of a reasonable doubt as to her guilt, that's a great advantage going in. So they don't have to prove anything. The burden of proof here is on the DA. So all they have to do is kind of make the jury think and say, well, I'm not sure about that. And if it's an important enough fact or a series of enough facts, that's all it will take. So if the jury says, maybe they planted the taillight, that's not guilty. That's a reasonable doubt. As long as you have a reason to assign for it. Well, maybe they planted the taillight. Well, why do you think that? Well, they said it took them 3 weeks to find it. Proctor is a dirtbag. He lied about the time they got to Dighton. He screwed around with the Sallyport stuff, which would have shown the exact time it went in. Tully's timeline doesn't match up with the CERT guy's timeline. There's all kinds of arguments you can make. Berkowitz miraculously just driving by. These are all things that a jury absolutely could say, that gives me reasonable doubt.
Nita asked why the interviews. Karen, just shut up. I'll answer them the latest. I think that they thought this would only come out after the first trial, which it did, and they didn't realize there would be a retrial. I think that's part of why she agreed to do this latest one, this ID discovery.
Well,
you've talked about this. What do you think, Attorney Bederow? You think it's probably not a good idea for her to do any press, right?
Anytime you speak before a trial, there is risk. That's the reality. And even if you're in a situation where you expect it to air after, and of course nobody's literally predicting a retrial, you're seeing the risk. There are statements that they're going to try to use. I don't know that they flip the needle that much, but I can understand why they would want to use it. It's really something that it's risky, and there's no way around that. They had their reasons for doing it. They did it. And, the DA is going out of their way to try to exploit from it what they can, such to the point that they're trying to, potentially pierce the privilege and kick people off. Obviously, none of these issues would come up if she didn't do it, but it's something they chose to do, and you just have to live with it.
Unidentified co-conspirator says, do the Commonwealth have to call Proctor?
They don't have to, but it's a hell of a quandary they're in. He is, again, the quintessential albatross. They're kind of damned if they do, they're damned if they don't. And if they call him, he's just going to get ripped a new one 1,000 times worse. Because you have to remember, the first trial was a disaster for him, obviously. But since then, he has been fired. One of the specifications for being fired was the possibility of having an actual bias against her. And also since then, he's been thrown under the bus by these very prosecutors who are going to blame him for the Sallyport fiasco. So on the other hand, if they don't call him, you're talking about a blinking, it's just a Christmas tree with the lights just blinking for everyone to see. What the defense would do through Buchanan is wrap him around Proctor and say he was the lead investigator. You were with him all the time. He was involved in this. He was the guy, and he's just not there. How does that look? And then of course the defense potentially would call him. Oh. So it'll be interesting to see what they do. But either way, the Proctor problem, as bad as it was in the first trial, is worse. Clearly worse.
Gonna be a lot harder this time. GU Knit says, Mark, I work close to your office. I keep hoping to see you every time. I'm waiting for the M57. Do people recognize you on the streets nowadays?
Sometimes, although not. New York is not really like that kind of place. It's happened. It's happened at the Garden a lot. That's for sure. In Boston, it's happened at a bar in Disney World, actually, which is strange. But no, in New York is like LA, and we're not talking that level. So everyone in New York is just doing their own thing, staring at their phone and ready to elbow you in the head, get out of the way. So not so much.
Comment from Sue says, expert qualifications. Do you have a Pulse University?
Oh, you know.
Ashley says they need athletes on the jury. However, I work for an athlete and wouldn't care about the videos. I have witnessed an athlete interview one way, and when it comes out completely out of context, you mean like a professional athlete, maybe? I see what they're saying. They're talking about the press stuff, right?
I don't think you're going to see a professional athlete on the jury. Yeah.
There aren't that many of them. I mean, how many of them live in Norfolk County? I think.
Well, actually, Foxborough is in Norfolk County, so
that's true. Yeah, that's
you
true.
know,
Maybe some Patriots players. A
well,
lot of them live in Rhode Island, I find. Yeah,
some live in Rhode Island. A lot live in, not Foxborough per se, but that area. And
yeah,
south.
I can see that. Yep.
Heading south, more towards like Rhode Island, but
True.
You're not going to get athletes on the jury. No way.
Do they get off easy? Can they say like, I'm traveling, I'm working? I mean, I imagine you're not going to take like Jason Tatum out of the playoffs, right? I mean,
well, if they did, we all riot. I mean, we have championships.
Yeah.
We can't have that. No, obviously, if somebody has a work conflict, then yeah, they're not going to serve on the jury. And yeah, I mean, there's going to be no athletes on the jury. That's just doesn't fit.
So Shanta, this is I mean, we all want to know this. I mean, I don't know why can't Mr. Bederow be on the defense team? I mean, this is the question that drives me nuts. I as much as I love having you here, Mark, I wanted to watch you. I wanted to watch you in this trial.
I wanted to participate in this trial, but you're asking the wrong person, because the I's were dotted, the T's were crossed, but I don't make the decisions. So that's all I can say about that.
Corey says, wouldn't the Commonwealth experts saying that the taillight pattern lining up with Officer John O'Keefe's wounds imply that the taillight was broken before the supposed crash?
I don't know. I mean, I'm still stuck on the whole, how you're going to shatter a taillight by hitting your arm and elbow. That just doesn't compute with me. And I'm not an expert, and the jurors aren't going to be experts, but there's going to be experts who are going to say that exact point or something similar. And I just don't know how they get past that.
Comment from Alert One Systems. Where was the last time you saw a U.S. attorney not share information with a state prosecutor? And only the defense, I think it hurt HB's feelings, Hank Brennan's feelings.
The only time it would ever happen, if there was a reason to share it, is because the state prosecutor is part of the criminal investigation, which by all accounts appears to be part of the issue here. I think, based upon the letters that you saw go back and forth between the DA's office and OPR in the Justice Department and the U.S. attorney. I don't think it hurts his feelings. I think this relates to ARCA. He needs them discredited.
Them out. It's like she can't have a defense because she might be found not guilty. I mean, that's it, right? CP Mulaney, Jen said in an original statement they were invited and didn't arrive. Why would she say that if in fact she was looking out the window? This is from Dr. Russell's gas.
So I think one thing you'll see, based on things we've talked about and reviewed in the second trial, is I would expect the cross-examine of Jennifer McCabe to be much more surgical and much more like death by 1,000 cuts. She is really vulnerable on her ever-evolving statements and from whoever she spoke to, and they go on and there's always going to be blaming the cop, got it wrong, and this and that. And I think there is a lot there. And I think, in my view, in the first case, there probably should have been more getting to all of those inconsistencies and also going in chronological order to show how they started to evolve. And I also think, importantly, when they started to evolve in terms of like real life and what was going on.
Question from Z. They say, how is Aiden's phone relevant, but not Birchmore?
I mean, I obviously I can't talk about Aiden's phone. Let's just say we don't expect him to be a witness, but you know, that's not our call, but we'll deal with that in due course. See, Lola saw that comment and there she goes.
Yeah, Lola's acting up. What does Lola want? Does she want a treat, or is she just looking for attention?
No, Lola is doing what all dogs do, except for allegedly one in this case, which is she's staring at the landing and hears people outside, and dogs tend to bark.
Oh yeah, yep. I got one of them. My little guy. Anything on the trail, he's going crazy. To let you know he's there. That's all it is, too. They just basically say, "Hey, what's up? I'm here. I want to let you know I'm here."
Well, that's what Lola does. The other one, Winnie, will like jump on the door and like pounce and jump up and down on the door and let them know, you know, I'm coming to get you if you let me outside. But
absolutely, I love dogs. How they all have their different quirks and personalities. Some will just sleep right through it. They don't care.
Yeah, not these two.
Yeah, not mine either. I'm just going back because I think I did miss a few super chats. I want to make sure I try to get them all up there. People keep sending them in. I go back and forth. There's a lot of them. But we've done good tonight. We've gotten through a lot of them. I don't think too many people are going to be mad at me this time. The last was the reunion show, Mark. People really, because I couldn't get them all. They went crazy on that show. They
came to see the flower and the ambient light. I'm telling you. That's what it is.
They came to see you. They wanted to know what Bederow had to say. They were excited that night. Marie says, what kind of jurors would you pick if you were picking the Karen Reed jury? What kind of profession?
Well, I mean, everyone has their generalized thoughts, but also you have to kind of go by feel to some extent if you've done this enough times. I mean, ultimately, you want people you like, you connect with, and support your view. Now, the problem in this case is the lawyers aren't going to be talking, so they get no chance to connect. And, you know, that's an interesting thing because, you know, certainly many of these defense attorneys are, you know, very charismatic in their presentation. And that would be a good chance to really start that process and get a feel. I mean, as far as professions, it really can vary. There are arguments that can be made many ways why, you know, a cop is good or a cop is bad. That would require like a 2-hour discussion, not just a shoot off the hip what it is. I mean, jury selection is, you know, as I said, where I came from, they used to tell us as young prosecutors, there was only 2 things you wanted to do in jury selection, right? Get rid of the kooks and brainwash. Now, they can't do that here because they don't have the opportunity to brainwash, and kicking off the kooks becomes a harder process when you're not asking any questions.
But when you say brainwashing, how does that work? Like hypnotize them?
No, you want to start laying out the themes and working in as much as you can what you expect will happen, what the issues are, and probing and getting them to agree and see if they're open to your concepts.
So it's more like almost like sales, you know, or repetition too. Like,
yeah.
And you check, like,
know. Yeah. You know, you want to let them know what potentially is coming and if they're going to have any problems with that. I mean, look, there's always these obvious topics. I mean, you're obviously going to be concerned if anybody is like so pro police to the point where the fact that there was, you know, officer down pisses me off, and you think somebody can't be fair of that, then they got to go. I mean, you'd hate to have to waste a peremptory challenge on that, meaning just you can get rid of them for any reason other than, you know, race, gender, color, that sort of thing. But you just want to brainwash as much as you can and make sure you get people who might see things the way you are. I mean, like, for example, you know, if you want the arc of people to be impressive, you know, one thing you're thinking is like, who's going to be receptive to that? I mean, I can think of a lot of other things. I probably shouldn't say them, about,
Say them. No.
well,
About what? About what?
I mean, just, you know, if you have people who have been mistreated by the police or the DA, or just have a reason not to be trustworthy, look what this case is, right? I mean, that may be something, at least initially, until you talk to, I mean, any individual, that you might think going in that that's a good thing. It's all these kinds of things, but you know, believe me, these people know what they're doing.
Absolutely. A sent $49.99. Thanks you so much, A. She says, I think Hank was so humiliated on Thursday. The defense team walking in, AJ's speech, do it, get some of the facts right, etc., that he retaliated with the motion he filed on Friday. It was really done out of anger and retaliation without knowing facts.
Well, he clearly doesn't know the facts. It's speculative by nature. He says, I need to see, or even the court needs to see in camera and decide. But it's not a common motion, certainly not in a murder case, certainly not less than 2 weeks before trial. But nothing about this case is normal. I mean, obviously it's not normal that the idea would generate from, you know, a defendant with an open case alluding to a conversation, you know, even if it's just kind of in passing. So nothing about this case is normal, but this application, even if it's not entirely frivolous, which it's not, to be clear, it's not legally entirely frivolous, but it's beyond the pale. I mean, it's just the kind of thing that prosecutors don't do, not in these circumstances, and certainly not a week before trial, and not when it can't possibly lead to devastating evidence of guilt. I mean, in the best case scenario for them, it's just another statement of what they already claim she said, I hit him, or something like that, you know, according to what they believe.
The clock has a great comment, and she says, Mark, every time your dog barks, my dog goes nuts. I have 5 of them. It makes me laugh. Thank you for always giving great content. I want to ask you a question, Mark. Does Lola or Winnie ever bark at the TV when dogs come on? Because I have one dog that stays here that goes nuts anytime an animal's on the TV screen.
They have. They, you know, not regularly, but you know, they have done that. Yeah, they're pretty wild, but I think Lola has barked more at the TV. But that's, you know, because she's Lola. She's, you know,
she's tuned in. She's tuned in.
She's laser focused, right?
That's right. She knows she's tuned into the environment. She's very aware. Kristen from Manhattan says, what's the process to get an expert who aligns to the theory of your case? Do you limit their scope, specify outcome you're seeking, trying to understand how Judd Welcher would come to his results?
I mean, experts are an interesting thing. I mean, if you believe a certain wacky commentator, anyone the defense hires for an expert is obviously a hired gun hack doing it for money. The reality is, when you look for an expert, you have to share with them evidence and what you're looking for, and you hope that you get an opinion that you want. And if you do, you might use them if they're credible. I mean, you don't want to just buy an opinion for someone who'll say whatever you want them to say, and then they're going to get clobbered on cross-examination because it's all bullshit. But, you know, for the DA to get their expert, I mean, they'll be cross-examined about, they were retained by the DA. Obviously, that expert that they got is probably going to get confronted with the Trooper Paul nonsense and have to disown that, right? And, you know, are you aware that that was another one they hired and went with? Well, not went with, you can't allude to the first trial, but, you know, had, and then they're going to get confronted with the ARCA stuff, and you have to see where it goes. But each side is, you know, essentially consults. If you like, you retain and you put them on the stand. I mean, that's just the way it is. But the problem, the burden the prosecution has, they can't just battle the archetype experts. They have to annihilate them. Okay, if they cancel each other out, that's going to lead to reasonable doubt. I mean, if the jury says, well, they could be right, we don't know, that's reasonable doubt. They need to literally wipe the floor and have the jury say, I believe the prosecution, and with all due respect to these nice doctors, I just don't think they have it. So that's a tough role for the DA to be in.
So the defense, 100%. Aussie Mel says, has Mark looked into Brennan and his request from the big Fed case he took on? I think talking about Whitey Bulger.
No, I mean, I don't. No, I mean, I don't research Brennan and his cases. I don't really care. I mean, I'm familiar with Whitey Bulger because he's Whitey Bulger. The only thing I could tell you about that case, which is interesting to me, not the whole Whitey Bulger saga, that's very interesting, but the case was a house money case, which is very interesting. In other words, there's no pressure to win. And this is different. There's a lot of pressure to win Karen's case. But, you know, when you're a defense in a case defending Whitey Bulger, in many ways, it's just house money. And you're going to, you know, poke holes and scream and yell and have a good time and attack this and that. But at the end of the day, you know you're not winning. So that's not pressure per se. It's a big case. It takes a lot of work. But pressure is, I have to win. And everybody's watching. And, you know, what am I doing here? So this case for him will be a lot more pressure than that was, as effective as they may very well have been in that case, poking holes and having fun. This is a much harder task because the expectation for people is you better win. That was not the case with Bulger.
That's right. It was an easy case for him in some respects with Bulger. No pressure. Everybody knew he'd be convicted.
Different kind of pressure, certainly.
Yeah. Can Aiden intimidate himself now that he is a witness? Can he yell at himself in the mirror? Who does he report it to? I'm here to report a crime. Airbuds in the kitchen as that question tonight.
I mean, we are in the upside down. I mean, what else can you say that we're even taking that as an almost serious question? I mean, that's problematic. Yeah.
It's a question I missed earlier. They want to know if you regret representing Turtle Boy instead of Karen Reed. Normal question. Mods, please be fair.
Not in the least bit. You know, it's an interesting case. I got called. It's interesting. I think it's a wrongful case. Certainly knew it would, you know, bring a lot of criticism and whatever. But you can't, you know, as a lawyer, you can't think like that. You have to defend who you defend, and you can't, you know, horse trade cases and stuff. No, you go what it is. For whatever reason, the judge saw that as a problem with the second one. I think that's unfortunate, but you can't think like that.
Oh, the good dog comes back. Imagine how different this trial would be if it were not in Massachusetts with all its special rules. More than likely, this case would have not even been brought to trial. Location.
I don't know if it's Massachusetts or if it's Norfolk County, to tell you the truth. I don't know. I'm not qualified enough and familiar with some of the other places, but certainly I think there's a lot of prosecutors elsewhere who would have been had every reason to look into Karen. That's fair. I get it. But, you know, we talked about this one of the first times we went on. To me, this was a no arrest, you know, no indictment case from the beginning. And once the ARCA stuff came out, certainly you get into the good faith of what are they doing. But, you know, I mean, reasonable people, I suppose, could disagree to some extent, but the level of vigor that this has taken on and some of the motions that have been filed are just stunning. I mean, for the prosecution to file. So they really are as all in gets.
Ollie Johnson says, do you think the Commonwealth is in for a reality check in the new trial?
I mean, I think having a retrial favors the defense for the reasons we've spoke about before. I mean, you'll have to see what they think they're going to do differently from their perspective, the prosecution. But I mean, look, they're doing it, so they must think they have something. But you know, I wouldn't underestimate the defense team. They're going to be ready for sure.
It's a question from Horace Bogardus. Says, are we supposed to understand that the defense has new third-party evidence that wasn't shown at the first trial?
I don't know. I mean, again, whatever was said at Sidebar, right? So we don't know. They went up there for some reason. I don't know what it is or what it could be. So we'll have to see. I really don't know.
Z Fabulous says, it seems insane that the DA can get info from Aiden's phone implicating Karen and him for witness intimidation when neither one of them have been convicted of that.
Well,
it's only alleged. How is that okay?
Well, the problem is there's only one defendant on trial right now. That's Karen, obviously. And whatever they allege that another person did shouldn't be admissible unless there's some link to her. So what they said at the first trial, what they're saying now is, well, it goes to consciousness of guilt. And one of the problems is that they always seem to leave out the kind of significant fact that when they had all this evidence and other stuff, they actually did go to a grand jury that declined to indict. And since they didn't indict, the judge should have known that. Okay. The judge, homework, I guess. The judge should have been alert.
I'm running a car for Sam.
Okay. Good to know. So the judge should have been notified that we had tried to indict for this conduct and a grand jury declined to indict. And if, again, a grand jury will indict anyone for anything at any time, 99.99% of the time, the so-called ham sandwich, if you asked it to. And at the first trial, there was only two people in the courtroom who knew this at the time the evidence came in, and that was Lally and McLaughlin. The judge didn't know, the defense didn't know, the defendant didn't know. That's really, and I know candor in the courtroom is like a big buzzword these days. That was very disturbing. And so you can't ignore that fact going forward as well. But they're not going to have, and I think, Tim said this very effectively the other day, there's no crime because a defendant is talking to another party. Okay, there's no crime that a defendant is talking to another party about a criminal case. Nor is there any crime that a defendant in a criminal case is even talking to another party about the evidence in their case or sharing the evidence. There may be other concerns because of the court rule or whatever, but that does not translate into conspiracy to commit witness intimidation. And again, in the trial that's about to start, it doesn't matter what they think the other guy did or didn't do. They need to link her to show her consciousness of guilt. And I think this is a lot of fishing, a lot of speculation. And I think ultimately, as you saw with the no true bill and whatever, the problem they're going to have is, they need some there, and they haven't really established that.
Question, how long before Mark gets his license for practice in Massachusetts?
Never. after
Not after this?
No, not after what happened a few weeks ago. No interest after this.
Mo885 says, could the push for April 1st start date have anything to do with Bev's new evidence policy starting in the summer?
I don't think so. I don't know. I mean, I'm not going to assume that's what she's thinking. I don't know. That's an interesting point. Although I thought it was, I thought those rules went into effect before then, but I don't know.
Not sure on that. I don't even know what the new rules are. I'm not sure what they're talking about. I know there's been some new rules, but I don't know what they are.
Rule 14 has become more liberal, more favorable to the defense in many ways or a few ways.
Excellent. I'm being told by my mods that I need to check Venmo.
Uh-oh.
Apparently there's some questions there. Let's check Venmo. Let me see if I have a couple questions. We're over time right now. Mark's answered like 80 super chats already tonight. I could try to hit the Venmo quickly if Mark, you still have time. I know your kids are
No, I'm good. They're not interested in talking to me right now. They're doing their own projects, so it's okay.
Okay, perfect. Let's look at a couple. I see one actually. Here it is. Sherry says, "Can you talk about what a civil rights violation is? The U.S. attorney role in them, and why someone in Karen's position has every right to call the feds to look into the investigation, and why the hell is that nefarious or
Well,
nefarious?"
I mean, if you plant evidence, I mean, that obviously is a civil rights violation. If you cover up, I mean, if the cops are corrupt, of course, that's going to violate all kinds of civil rights. That can be, your right to due process. It could violate your Fourth Amendment rights. You could go on and on, but corruption generally relates to civil rights. It's generally going to be investigated by the Civil Rights Division, of the U.S. attorneys. I'm sorry, I'm just typing something on a work thing. That's what they do. But the other thing is this, and I don't want to talk about the details of federal investigation other than to say the fact that they don't return charges or anything doesn't mean anything other than that. They never give their reasoning. They don't explain. I mean, it's not something one way or the other to read into, but that's all I'll say about that.
RGB says it does not seem reasonable that John was out in that weather from 12:30 and still alive. Science should take the lead. I wonder if they have anyone on that. What do you think? Because that seems like a big point in this.
Well, I don't want to speculate and get into those kinds of things, but science, obviously, if it's credible, hard science in particular, if you have it on your side, you ought to use it and use it well. I mean, that's what they're doing with ARCA. We'll see if they do it with other things. I mean, there's a lot of experts on the witness list.
Well, I got to make sure I got Bonnie up. She called in last time. She was one of the ones we missed on the big show last time when you came back for the first time. And she says, "You are amazing." She's talking to you, Mr. Bederow. I'm saying Mr. Bederow now because of Kim. I love that. She calls you Mr. Bederow. Mark, I know you like Mark better. And she says, "Thank you for saving my lunch from the intersection last time you were in town." Apparently you saved her lunch. Do you even remember doing this for Bonnie?
Did I save it by consumption? Did I eat it? What happened?
No, apparently she said something about like that the cops or someone, like she had dropped her lunch and left it there, and someone was going to knock it over, walk like the crowd, and you said, "Hey, is this your lunch?" And you saved it. I don't know. You don't remember? You just do these random good things and you don't even remember them.
Truly don't remember, and that maybe that's early senility. I don't know. I mean, it wasn't that long ago that I was there, and I don't remember. But you're welcome. But you're welcome.
You're welcome. I hope she enjoyed the lunch.
I hope so.
This is a question that came up before, I think, but let's ask it again. It's a good one. Danielle says, "Mark, if you were on the defense, who would you want to cross the most?"
Jennifer McCabe and Brian Higgins, but McCabe first, Higgins second. Those are easy 1 and 2.
Now they want to know about your flooring. Did you get new flooring, or is it a different angle on your camera today showing your flooring?
Yeah, nothing's changed. Maybe the screen got moved. It's nothing's changed.
Every time I try to get catch up with the super chats, a million more come in. I just gotta warn people. I don't think we're gonna be able to answer any more tonight. So please don't send any more if you have questions. Hi, especially for Mark. Hi, Mark and Mark. Aiden just wrote an article on the new accident reconstruction guy. He is from Mass State Police. He left and trained Trooper Paul and actually has proven in courts to be wrong on some of his cases. That'd be interesting, huh? They're
Well, that would be bad, obviously, for them. I don't know much about it. I'll have to take a look at it. But I mean, when you hire a scientific expert, it helps that they be right 100% of the time when you're talking about science.
A lot of people are thanking you for representing Turtle Boy after that question came up. They're very thankful that you're helping Aiden Carney and you're his attorney.
Yep.
Just see if I have a couple more. I want to see if we can get all of these in, hopefully. We did ask that one. I think we're all caught up. I'm feeling gonna notice a couple more. But I think we did good, Mark. I mean, there's over 100 tonight. This is another one of those nights that just kept coming in. Here's one more. Has the defense confirmed the feds are done?
I
You don't
can't.
know, right?
I can't.
You can't say that. You can't answer that one.
I don't want to get into
Guardrails. Guardrails.
I don't want.
Yeah.
Sorry.
That's all right. We get it. We keep asking the same questions about the feds, I feel like. Bederow's not budget.
Not about that. No.
Yeah. That's actually like I don't know. It's funny. It's the stuff you don't answer to me is kind of revealing in a way too. So I like when you say I can't answer.
Can't discuss that either.
I don't want to get you in trouble.
No.
I love it. Anything else you want to bring up tonight? Because there's been a lot of motions and hearings, and I always like to go to the crowd and see what they want to know. But I feel like there's a lot that we didn't cover tonight that I know you've been on other shows discussing. Anything important that you think we didn't touch on tonight?
No, I mean, to me, the biggest thing is it seems obvious at this point that there isn't going to be a hearing on the motion to dismiss. And I think that's a shame because this case screams for a hearing on the motion to dismiss.
Have you ever seen that happen before where you're in a trial and you have a motion to dismiss and they don't even have a hearing and you feel like it's very worthy?
Well, this is another thing that's very, strange about Massachusetts, in my view, about Massachusetts procedure. In New York, there is a schedule of when you have to file these things, and you would make the motion to dismiss well before trial such that you wouldn't have this issue of timing. But, in Massachusetts, as far as I can tell, there's no real rhyme or reason to when you can file these things, and it can create these kinds of burdens that are problematic. But you do have a trial date that is circled. It appears no one's willing to budge, and it sounds like as a result that this motion to dismiss is just going to be swept through the cracks as if it didn't happen. I mean, they still have to get a decision. Clearly, you can't try the case without a decision. But just the math doesn't compute for a hearing because that hearing would take a couple of weeks.
Honey follows up about the lunch that you helped save, Mark. She says, Mark, my lunch was on the ground when you guys, all the cameramen, were kicking my dish into the intersection and you stopped the crowd and let me go grab it. You're a hero. You saved the lunch. I want to know what it was. Was it
That's a lot.
beef? Was it ribs, steak? What was it? Tuna fish?
I don't know.
Maybe it was a salad. I wonder. I wonder what she was eating for lunch. Thank you, Bonnie. You are a hero. You saved her lunch.
I'll allow it, but I don't remember it.
That would make you a hero to me if you saved my lunch, because that's me. I like to eat.
Lunch is important. Yeah, you got to eat.
You saw me on the Collusion. Did I focus on eating?
You throw it down. Yeah.
I throw it down. That's what I'm good at, eating.
Yeah.
What are you good at? I dabble in eating.
Well, the tangerine beef is very good. Yeah.
Oh, that was good. Yeah. What else do we get? You get like the wings. We get the crab rangoon.
Yeah.
You ordered a few things. I'm trying to think what you ordered.
You got to get the poo-poo platter with the little fire. The whole.
Oh yeah, the fire. We got to get the fire going. Yeah, I love that. I love the flame. You get to heat it up, and if you want to.
Yep.
Cat Q says, "Did you notice how Mark's dogs react to sounds? What about if Chloe, the morning that everyone was on Albert's lawn? Come on, I know, right? I mean,
I think most dogs that can hear. I mean, and I don't think there's any evidence that Chloe had. Some dogs do go deaf in older age, but dogs that are not deaf would almost certainly wake up to that. And I think another underestimated lack of dog reaction would be somebody you may recognize storming into a bedroom without much notice and getting all traumatic. And, the testimony about what McCabe did, waking up the Alberts, that a dog in the room, the idea that they would not leap up and at least just get fired up is, in my experience with my dogs, that's hard to believe.
All right, one more super chat. Nita says, what if truth and transparency is right and Jen didn't have her phone, but Matt had it instead? What do you think? Does that make any difference in the end, really?
I mean, it's bad. Obviously, it would mean if somebody did that Google search from that family who had been at 34 Fairview at a time where they should have no knowledge of anything, it really doesn't make a difference who would have done it if just one of them did it. And I mean, there are we've talked about this before, like, ARCA is one of them, but the 227 search, if that's true, if that's accurate, if that's established, or at least credibly established, that's a case-ending fact too. I mean, if a jury thinks it's possible, reasonably so, that search was a 227, there's no explanation for that other than that somebody in the house did something or was aware of something terrible that has nothing to do with a car accident.
Now, this isn't a super chat, so I can ask this question. I like this one. Jaron says, wait a second, is Bederow a Swiftie? Are you a Taylor Swift fan?
Well, by default, I mean, if the daughter's a Swiftie, that kind of makes dad without any say in the matter one, no?
Oh, that's so cute. Have you taken her to any Taylor Swift concerts yet?
No, but I'll tell you what we did do. Through a very good connection in the movie industry, if you recall, when she made that movie, like last, I don't know, October 2023, we actually were invited to the premiere of the movie in LA at the Grove, for those, in California or who watch all that TMZ stuff where they film it. And they rented out, it was red carpet, the whole Grove, the whole family went out to LA for a few days. And we were in Theater 1, which is, the so-called VIP theater. And a very well-known lady who was the center of attention came into the theater that night. And obviously that was quite a moment for her. There was some interesting people right in front of us. One of the actresses from Law and Order was there. Adam Sandler was in there. A couple others, but yeah. So we got to see Taylor Swift in person at the movie premiere and hang out in California for a few days. So that was cool.
Excellent. That's a good question to ask. I'm glad you got to go out there and experience that, the premiere. That must have been awesome.
Yeah, that was in October.
Yeah. Did you get glittered up? Did you wear the glitter and all that?
No, I have pictures, obviously, of all. No, you put on some, nice clothes.
You got nice clothes. You got all black tied up.
Not that nice.
Not that nice. Not like.
It's still a movie theater, but we still have a lot of mementos from that trip. So that was pretty cool. Awesome. I didn't get the whole movie thing. The idea of like watching a Taylor Swift concert on a movie screen, to me,
simulcast, yeah,
struck me as, I don't know, not my kind of thing. But every woman in there, and I'm talking grown woman, not just kids.
Not just kids, yeah.
Standing up, dancing, singing. I mean,
they love her. They love her.
Her effect on like grown women is, not just the kids, is astounding.
Amazing. Yes, yeah. Music does that to people. It's so true. I get like that for Pearl Jam.
Yeah, it's kind of a little different. Yeah,
cynical as I am, I still have those bands I like. Texas Prime says, "May I please ask Mark when he sees AJ next time to give him a big wet cut kiss from Texas Prime? I would appreciate it. No offense, Mark. You're my second choice."
Well,
I don't even know if you're going to see AJ again, will you? I don't know.
Yeah, no, of course. That's a strange conversation to have, but I'll certainly
think about it.
I'll let him know. Yeah, I'll think about it. But yeah, no, that's
maybe he'll hear it now, because sometimes those attorneys. I know that Alan, when I met him, said he, before you were, part of the team, he used to tell me that he was watching Bederow every night on my show, so I know they watch when Bederow's on.
Well, that's one of
Andrew-
the it would have been very fun to try that case with that crew. Believe me, that's
Definitely.
one of the.
It looks like fun. I when they get these videos they're putting out cooking dinner, I'm like, oh, I'd be cooking dinner right there with them if I was part of that team. That would be the funnest part, cooking dinner together every night. I love cooking. I love food. Like I said, I'm a food guy. They made fun of my chicken wings the other day with the carrots, but that
Carrots.
that-
Yeah.
the carrots are awesome. I love them. Sorry. I put up my lobster. I had a lobster meal the other night, and they were all like, "Where are the carrots?" No carrots in that one. Yeah. Audrey Presti says, Attorney Bederow, you are the best. I said I was going to stop, but I feel like I have to. More of them came in. We're almost there.
Grift away.
Michelle, why hasn't anyone seen the Jeep? Was Higgins even driving the Jeep?
This has always been one of the weird oddities in this whole thing, and you have those three kids in the car who have some pretty favorable evidence, for the defense, if you remember from the first trial, particularly the female. I think her name was Maxon.
The Maxon, I think. Yes. Yep.
All three of them could not have been any clearer that there was no Jeep. And, the people who said there was a Jeep were, Higgins and the McCabe's and maybe a few others. And you can't negotiate these two different stories. I mean, they don't mesh. Now, why did they feel so compelled to put Higgins's Jeep there? I don't know. Was it the plow? Did they want to try to suggest that, she backed into the plow? I don't know. But that's a strange thing that, you have to wait and see if it's a big deal or not going forward. But it's very rare that you see that level of disagreement between people who are all adamant, and they can't both be true. And you have to ask yourself, who's more credible? The three kids who just showed up and just don't know anyone really, or, Jennifer McCabe, Matthew McCabe, and Brian Higgins, who, arguably have a reason to substantially favor the prosecution. And what do they get out of putting Higgins's Jeep there, by the way? That's kind of like part of that is, what do they get from that? But on the other hand, what do these kids get from taking it out? So
good questions. Grift away should be a bumper sticker, someone said.
Grift away.
Did you see Kevin's putting out a book? We've talked a lot about Kevin tonight. It's funny. He's got a new book coming out. It's like I don't know, a lot of pages, like too many pages. I can imagine. Are you going to even peruse it? Are you interested in reading even in like one page of it?
No. I mean, there's nothing to me that's even remotely interesting about that. When is the book coming out?
I don't know. He's doing pre-orders on Amazon right now.
I mean, are we not going to include the second trial as part of the book? Because there's a pretty good chance the book could become even more irrelevant than it probably is if the book is advocating a position that gets, it's not consistent with the outcome of the trial, if that's the case. But
that would be a very short shelf life.
What are they charging for this book?
It's like I think it's like $7 or something, like $8. It's not, like online Kindle type thing.
To each his own. No, I have no interest in reading it, but whatever. It's a free country. I mean, if somebody wants to buy it and read it, God bless.
Yeah, that's the funny thing. April 1st is the day they're putting it out. Like, oh,
well, that's my point. I mean, like, so it's what is he going to do? Publish an addendum? I mean, it's kind of premature. No,
it's kind of like when he did the closing arguments before the defense made any defense witnesses.
Who wants to read a book before the main act? I mean, what's the point? Where does it end?
You should have asked Bederow for some advice.
Where does it end? By the way, the second trial is starting in a week, and we'll see. I mean, it
wouldn't have been that long to wait. I mean, really. Let me ask you one more question that's not a super chat. We talked about this. I know it probably hasn't changed, but they only had a limited amount of witnesses on the defense side. I think it hurt them last time. I think they felt like they thought it would be a strong showing just to put their best witnesses up, basically saying, we don't need anything else. We've already won this case. But I think that, like, juries look at things like how many witnesses the prosecution had versus the defense, and they look at volume sometimes as having some kind of, credence. It's credible that how many witnesses the prosecution had. Do you think that they should just throw every witness up they can on the defense side this time?
No, I don't agree with the volume argument. I think they like solid facts that would support a position, and actually the shorter you can do it looks more impressive than just throwing it all out there. Do I think that they'll probably use more this time around? I think so. We'll have to wait and see, but I think it will probably be. I think a lot of things will just be maybe a little more intense. I think a lot of the cross examinations will be more emphasizing again the inconsistencies and really drawing attention to them. But in terms of witnesses, just based on the witness list that they presented, yeah, I think you'll see more.
Excellent. I want to thank you so much for being here tonight. Krister also wanted to thank you. She said you're an incredible human. This last one came in, Texas Prime, and they had a question that says, why is it the Mass State Police found misconduct with Proctor, but the feds closed the case without any findings?
Because they're looking for evidence of crimes, which, misconduct doesn't necessarily translate to criminal activity. I mean, it could, and again, when the feds are bringing things, they need to have a good faith basis to believe there's certainly probable cause, but they don't bring charges unless they're satisfied that they can prove them beyond a reasonable doubt. And it's just a different standard.
Excellent. I want to thank you so much for being here, Attorney Bederow. Do you have any shows upcoming planned this week?
Not yet, although I think possibly, is it this week? Maybe Thursday, I think.
Maybe Thursday.
Thursday with Brian, right? Yeah. Or Wednesday, Thursday. I'll have to check.
One of those days.
One of those
You
days.
do
Yeah.
have coming up with LTL.
Yeah, I think so. Yeah. I think it's this week. I have to check the email more carefully. Yeah.
Awesome. We'll take a look at that. I'm looking forward to seeing you on there. I want to thank you for everything you do. I'll be hitting you up again like I always do, especially when the trial gets going. I can't wait. April 1st. What's that?
Although I say grift away. That's what you all do. Yeah. Just
thank you for helping me grift away.
Whatever I can do to help you grift away.
You're the man.
All right.
There's one, Chinatown. They love Chinatown. Can you say that for us before you go out?
Forget it, Jake. It's Chinatown. I mean, look, it's actually really appropriate. And it's also, on top of that, if you like classic movies, Chinatown is as good like film noir as you'll ever get. And you have to know the context of that quote. It's just something terrible happens and he's looking to get, and they just tell him, forget it. It's the way it is. There's nothing you can do. It's the way it's going to be. Don't even bother. Forget it, Jake. It's Chinatown.
The way it goes. That is a good movie. If you haven't seen it, definitely check it out.
John Huston, Jack Nicholson, Faye Dunaway. I mean, again, if you like classic, that's as good as it gets.
Definitely a good one. Yes, our chat agrees. I want to thank you again, Attorney Bederow. Thank you for being here, and we'll see you soon. And have a great rest of your week.
You too. All right, take care.
Have a good night.
You too.
Thank you. We're the Young Jerks. That was Attorney Mark Bederow. He never disappoints. That was just amazing. We answered like 100+ super chats tonight. I think we got most of them. And maybe a couple people I missed. I tried to get them up on the screen. Please don't be mad. I'm trying to do the best I can. We get that many, and it's Attorney Bederow, and he's got a lot to say. I try to do my best. Yeah, he does. He calms my anxiety too. So true. Always feel better after we have a Bederow show. I heard JFK was in the chat. Thank you, JFK. I'm looking for you right now. There he is. He's saying hi to people. What's up, JFK? I want to thank everybody who's been watching tonight. I want to thank our moderators. It's Jen O. Thank you so much to Jen O. Thank you to MJ. She bought some memberships tonight. Thank you so much, MJ. Thank you to Sarah and Shock and Horror. She couldn't be here tonight. She had some plans, but she is one of the great mods that we have as well. I want to thank Stephanie. Stephanie, thank you so much. She's amazing too. And Scott McGinnis. Thank you, everybody who's been super chatting tonight. I'm going to say, too, if I ever miss your super chat and you're mad at me, just hit me up, mjcboston1 at yahoo.com, or hit me up on Facebook or Twitter. And especially if you haven't gotten a sticker, if you want one of these stickers, we got a bunch of them. We got Young Jerk stickers. We got 3M stickers. We got Young Jelly stickers. I'll hook you up. If I miss your super chat, I'll send you some free stickers or something. Just hit me up. If you already got the stickers, we'll figure something else out. Don't be mad. We try to get them all up there. Yes, thank you to the mods. I want to make sure that everyone thanks the mods. If you haven't liked and subscribed, please like and subscribe. We got some more shows this coming week. Tomorrow night, we're going to be airing the Kittens Select Board meeting, which should be fun. There's an election coming up, so that should be exciting tomorrow night. On Wednesday night, I have an attorney I've tried to get on a couple times. He's coming on. Happily, angrily lawyer. I can't wait for that. He's known for the YSL trial. He's got a lot to say on Twitter. He's done some shows. I'm looking forward to having him on tomorrow night. Wednesday night. Thursday night, we're going to have another big show here. We're going to raise money for Karen Reed and have a bunch of different guests. And I got a much more planned, too. There's so much going on here. Can't wait. JFK says James Jackson is changing his clothes for the 5th time today. Does James got outfits? He's like Hollywood now. I can see that. James dresses very sharp. I should probably hire him to help me with my wardrobe. You know what though? My audience is helping. I don't know if you saw the new jacket I got, that Canadian Goose jacket. Bill Reed. I got to give Bill Reed and my audience, the supporters, the people, some of my mods and some of the other people like that support us, like Uncle Frank and some other folks on Twitter, they chipped in to buy me that Canadian Goose jacket. So they're trying to help me get more stylish. I got the Bill Reed Canadian Goose jacket. I'm loving it. I can't wait for that. Thank you, JFK. You are too. And if you don't know, follow JFK and James Jackson. They've done some great work this year, especially drawing out Higgins. That was, I still laugh at that. You wrong. You wrong. A couple decorated dudes. They entertain too. I love how those guys are straight, serious. They're who they are, but they have fun. They have a lot of fun. I like them. And you know what's great about this is so many YouTubers now. There's so many. It's funny. Some people look at it as competition, but I think we all have our own style, and which develops different audiences. Some people like one show is their favorite or another show, and there's something for everyone here. Which is, just being yourself. You kind of draw your own audience. Like James and JFK definitely have a defined audience that love them. And I could see why, because I like watching them too. They're fun. There are a lot of different shows I like watching too. I like Auntie Deb. I had fun on Oblivious Benson the other night. I also like Nurse Kim. I watched her with Bederow the other night. She's doing great. She does really good too. So there's always different styles. I also like, obviously, like Mazza Media and LTL. And there's others. There's one that she commented tonight. I like her. AV to the 7th power. I was just checking out her. I like her too. There's something for everyone. Oh, yeah. You think, oh, you know what though? Yeah, Miss McKinney. I'm actually in talks with her. It looks like she's gonna come on. So that's one of the ones that's upcoming. Pretty sure she's gonna come on. So yes, thank you, Beth. You want us to send you to Runkle, please? I can't go do that unless I go upstairs, and I'm not locked into YouTube down here. If I had known, but everyone should. If Runkle's going to be on right now, everyone should go check out Runkle. He's funny as hell. So go check out Runkle tonight. Yeah. We rate. Let's go rate them. I without me redirecting, because I'd have to go upstairs, log into that computer. I'm not actually logged on YouTube on this computer. I should actually get that straightened out. I still haven't done that after having a new computer for a month. But we can just all go over there. Why don't we just go find Runkle of the Bailey, and go all jump over there. So we don't need to. Maybe I could throw a link. How about we do it that way? I'm gonna throw a link. I can do that. Runkle of the Bailey. And then we can pin it. Let's do that right now. We'll all head over to Runkle. I feel like I owe Runkle too. He's come on the show. I like him. I enjoy him. He's another one. There's so many good creators here. So let's do that right now. I'm going to throw it in there. Let's do a Runkle raid. Old fashioned way. We just go right over with the link. I'm going to pin it in the chat. Let's go. Let's go hit Runkle. I'll see you over there. Thank you so much. I'll see you again tomorrow night. Tuesday night, Can't Select Board. Wednesday night, I got a new attorney on the show. And more upcoming this week. There's a lot more planned. We will see you very soon. Thank you so much, everybody. Have a great night. Let's go watch your uncle. And make sure you subscribe to JFK, who is in the chat tonight as well, if you haven't already. And we'll see you guys all over at Runkle. Thank you so much. Have a great night. Peace.